the hearing in the Investec appeals.
May it please your Lordship, I've got 10 minutes. I won't go any further, if I may.
I think indeed there is. We were going to rise tomorrow at 3:45. I understand it's not possible, so that so not necessary rather, so that we can have an additional 10 minutes tomorrow. If everyone wants to put their schedule back.
My Lord, I just want to make 3 points on the application of Article 32 appeal in conclusion. The first is about the purpose of characterisation and framing of these rules of private international law. The second is about the special position of Guernsey. And the third is, just to remind you once more, about the very special facts of this case.
Yes.
Your Lordships will have seen, and your Lordships have heard, the quotation of Lord Justice Ald's speech, which my Lord Mance quoted in Raiffeisen, in Lord Justice Ald's judgment, rather, in Macmillan and Bishopsgate. And it's quoted in our case, and just for your record, it's at MS 14167. I'm not going to ask you to look at it, but you'll recall that what Lord Justice Ald said is that the purpose of characterisation and finding the applicable law is to strive for comity between competing legal systems. The court shouldn't be constrained by particular notions or distinctions of the domestic law of the forum, or that of the competing system of law, which may have no counterpart in other systems. And nor should the issue be defined too narrowly so that it attracts a particular domestic rule under the lex fori, which may not be applicable under other systems. So the question here we submit is this: would the application of Article 32 of the Trust's Jersey law promote comity if adopted by the Guernsey court? And if one looks at the purpose of the Article 32(1)(a) provision, its purpose is in effect to create a fiction about persons. It creates the fiction that a trustee dealing with a knowing third party is acting in a representative capacity separate from his personal capacity. And elsewhere, one finds all sorts of other statutory fictions that apply under one jurisdiction's system of law. After all, the company is the best example. It's a fiction that the company is distinct from its members. And we say that as a matter of comity, the courts of the lex fori should recognize these special rules about the person, the fictional rules about the person under the other system of law, especially, as I'll suggest in a moment, in a context like this, when there is, so far as we can see, no clarity at all about what the appellants say is the alternative competing system of law.
Why do you need to have recourse to comity? And we are concerned essentially with a rule-based system. If you are right in the submission that you just made, then this is a feature of the constitution of the particular entity that you are suing, that he has, so to speak, two bodies, so that perfectly orthodox application of private international law would lead you to the result for which you're contending. It's not a question of comity.
Well, since your Lordship's of course right, but ultimately all rules of private international law have at their root a desire to achieve a result which promotes comity.
Well, I'm not sure about that. They basically are concerned with establishing the most appropriate jurisdiction for particular issues, And that may well be most aggravating to some jurisdictions with a particularly long-arm tradition.
I tell your lordship's point. But
It's a rule-based system.
my lord, I take your lordship's point, but we still strive to some extent to achieve comity. The second point.
So this is slightly odd type of fiction, though. It's not like a company, where a company is either a company or not a company. Or it's not even like a personal representative, where the personal representative is either acting in all respects as a personal representative or not. This is a case where apparently the trustee is only acting as trustee if the terms of or the nature of a particular third-party arrangement is such that a third party knows that the trustee is a trustee. In other words, the capacity seems to be linked to the nature of the third-party transaction, which I haven't come across. And what is your best analogy? You refer, company doesn't seem to me to be terribly helpful. You refer to some other examples of people who act in two capacities, personal representatives may be one. What is the clearest case which then says that in PIL terms they are regarded as having two capacities, and in their PR capacity they're only liable to the extent of assets which they have as a personal representative, for example? Is there such a case?
I don't think one can find an absolute precise parallel outside this one, but that's why we're relying on analogy.
Yes, you say in your case that there's no precise case in point, but we should be looking at situations where that is obviously right, and I suppose a personal representative might be one situation where one would think...
It's similar, it's not absolutely identical.
No, what's the difference? The difference is... the difference is what?
Well, the difference is because a personal representative may go on to take steps and enter into contracts... which may be personal, which may be undertaken in a representative capacity.
Yeah, but then he binds himself 100%, doesn't he?
Well, it depends on the system of law you're dealing with. And so, for example, in most of the states of the United States under the Uniform Probate Code, that's not the case.
Well, I know, but that may point to difficulty if we can't find something in this jurisdiction. You could probably find the authority in the United States for the opposite proposition too.
Well, but look, the danger is, if I may respectfully say so, we're looking at it through English eyes all the time here, looking for analogies, and that's because, with one exception, that's where we all come from, although many of us have had dealings in other jurisdictions.
Yeah, so we've got to look at it a bit more from across the channel. Most of the way across the channel.
Well, but not just, but there are. It's not just the Channel Islands, as I say.
In the Channel Islands, the whole of trust law is an import from England, save insofar as modified by statute, which obviously it has been in significant respects. But as I understand it, there was no trust law domestically generated. It's essentially a wholesale adoption, or has traditionally been a wholesale adoption, of English trust law.
My lord, I think that must be right.
Well, we had this in spread trustees, didn't we? Carry on.
Sorry, my second point is perhaps rather an obvious one, but the board is sitting on appeal from Guernsey and has to look at it through the eyes of a Guernsey court. And Guernsey and Jersey have many statutes, not just the trust law statutes, which establish different sorts of business structure, which operate both to regulate the internal relations between members of the structure and the structure, whether it's an entity or otherwise, and also regulate external relations with third parties. And I give the example, the protected cell companies and foundations, which don't exist in this jurisdiction. And one would have thought that in Guernsey and Jersey, they'd be especially astute to recognise and give effect to the special regimes applying to those sorts of business structures in other jurisdictions. Above all, one would expect Guernsey and Jersey to show respect for each other's structures. And the third point is just to come back to the facts of this case. As we will see in a moment, this is not a case where the very informal documents evidencing the transactions said anything to the effect that the trustees were intended to be personally liable. And no one directed their minds to the question of what the proper law of these informal arrangements was. And so it's a very abstract argument we're having here about a competing law which no one has identified. And it's not even apparent, putting it at its lowest, that anyone gave the slightest thought to the idea that the trustees could be personally liable. I will be showing reasons why, as a matter of inference, it's obvious that they weren't intended to be personally liable when we come on to the contractual limitation case. But why this is important, my lords, is this. We accept that under the Jersey statute, as under the Guernsey statute, it's always possible for a trustee to say, well, I'm going to accept personal liability. I'm going expressly to accept personal liability. That's, you can contract out of it. But that is a very different sort of case from one where no one seems to have thought about it at all. And what is being suggested and submitted by us is that what is, in a sense, the default rule in Jersey and Guernsey should apply in this case. So unless I can deal with any further questions you want to put to me.
Yeah, very helpful. Thank you very much indeed. Where do we go? Lord Goldsmith.
Lords, just a very few points in reply. The main burden of my submissions was that there's nothing in Section 32, even if it applies, which actually removes the common law rights to exoneration and reimbursement subject to Article 26(2) and whether there's a gross breach of trust. As I understand my learned friend's submission, there have been most 2 points that he's put against that with which I wish to deal. One was to say that the construction of 32(1)A has to be informed by the contrast between 32(1)A and 32(1)B. The contrast is between 32(1)B, which is a statutory statement, we say, of the traditional position of a creditor, an unlimited claim against the trustee personally, together with a subrogated right to the trustee's indemnity, and 32(1)A, which on my learned friend's reading would take away the creditor's rights. The reason why the creditor's rights against the trust assets are expressed differently in the two provisions is that 32(1)A recognises, we submit, the right of exoneration, and 32(1)B is describing the more general right of indemnity. What I wanted to underline is his suggestion that it's somehow inappropriate for 32(1)B to be restating the common law position if...
Why should 31A be confined to exoneration?
It doesn't affect my argument, my lords, whether it is or isn't.
No. I mean, an alternative view of 32(1)A is that it affects the third-party claim. Any claim by the other party shall be against the trustee as trustee to the extent of the trust property.
Yes, I'm using shorthand, but my lord is right. It doesn't make any difference to the submission I'm making, which is the right of indemnity or the right of exoneration subject to the common law limitations, which are provided the liability is being incurred reasonably or the trustee is not in breach of trust, are observed.
Well, wait a minute. If my analysis is right, it's not concerned with that. What it's concerned to say is that there's a limitation of liability which the third party can establish against the trustee.
Yes.
It leaves open what the position is between the trustee and the beneficiaries, and it also leaves open the question of enforcement. I mean, it seems it may suggest that there is some right of enforcement. Certainly, it doesn't say anything that to the effect that the trustee could get an indemnity if he wouldn't otherwise get it. Is the main point you're making?
Well, the main point I'm making is it doesn't say he doesn't get it
Yes.
in circumstances.
Another way of putting it is to say that the difference between 1A and 1B, the different wording reveals that in 1A there is no personal liability, in 1B there is,
Yes.
and everything else is left intact.
Everything else is left intact.
Yes.
Exactly so, my lord. And the question, why does 1B do anything at all? It's useless, says my learned friend. It's not. The world is divided into two categories. The legislature has chosen that those categories are knowing and unknowing. The categories could have been suspecting and not suspecting, or being informed and not being informed. In other words, the statute has to define what the characteristics are of the people who fall into the personal liability category. And we know that the law itself was subsequently amended to change it from knowing to from being informed to knowing. So you need to define what the category is, and when you've done that, you need to put that into the statute in both limbs. It's simple as that. It is important, indeed it's essential that that is done. But that's the only reason why they both are there. Otherwise, they leave the common law intact, which is my fundamental...
Well, you could, I suppose, say that bit in brackets in B, referring to the indemnity, is really there for the avoidance of doubt.
Yes.
Saying effectively, don't fear, trustee, that just because your counterparty didn't know you were a trustee, you don't get your right of indemnity.
My lord, yes.
You may be personally liable, but you still have your right of indemnity.
Yes. Or don't fear, trustee, that because we've now used the words personal liability, that means it's all got to come out of your pocket.
Yeah.
You've still got your other rights.
Yes.
Exactly so.
That's why it's in brackets.
Yes. Yes, my lord. I respectfully adopt that observation. So that's really the first point. The second point I understood that was being made was to say, well, somehow, and particularly because in B it talks about a right of recourse to the trust property, that somehow that was giving an unrestricted right to all the trust property. Well, my lords, no. That's the right way to describe it. Indeed, I sort of struggled overnight to think what other word you could use. You can't say a right of recourse to a trust property. You can't say a right of recourse to some trust property, because that would raise more questions than it answered. You could spell out in long form exactly what you meant, but that would be unnecessary. So neither of those points in our respectful submission of construction change the consideration. He also submitted that, as I understood it, that 32(1)(a) couldn't mean what it says because that would be to diminish the rights of the creditor. And we would respectfully suggest the one thing that's clear is what is intended. It is to diminish the rights of the creditor. That's why it says only to the trust estate, trust property, whether that means limitation cap or whether it means indirectly to the trust property, doesn't matter for the purposes of this argument at all. And that's the argument that matters. But if one is looking at the question of damage to the creditor's interests, well, as my Lord Briggs pointed out, this is a situation in which you have in competition the rights of the creditor, the rights of the trustee, and the rights of the beneficiary. So far as the creditor is concerned, he can at least take steps to improve his position or not to enter into it. He can decide not to have this contract or to insist on additional protection, security, co-obligation, guarantee by the beneficiary, whatever it may be. The beneficiary may not be able to do anything. The beneficiary may not know about the transaction. The beneficiary may be a minor. The beneficiary indeed may be unborn, and therefore has no control over how the obligation is entered into. All the beneficiary can count on is that the trust instrument and the obligations on the trustee will be faithfully performed. He has to have that hope and expectation. And then...
You have to, I mean, basically you say that therefore it's most unlikely that this is intended to affect a fundamental or any change to the position
Yes.
as it normally applies.
Exactly so.
There is no, I think, no legislative history, travaux préparatoires, of this law at all, as far as one sentence.
Well, your lordships have got it. What I say about it is the one thing that it is informative about is it doesn't show anybody saying this is the change we're making, or let's talk.
It doesn't say that English law is thoroughly unsatisfactory in these respects on this point, and we get away from it.
No, it doesn't.
There's no hint that this is designed to enhance creditors' rights.
No. So, my lord.
Or indeed diminished beneficial.
Yes, exactly so.
Yes.
Exactly so. And I could pray in aid to the general principle that if a statute intends to take away a common law right, it does so in clear terms. And that's a proposition too well known to need citation of authority, I would respectfully submit. I think the two other points I wanted to make under that head. One is that I think that what my Lord Sumption said a moment ago, in fact, answers the question in any event. So far as Jersey is concerned, whilst, as my Lord Hodge rightly pointed out, there are important differences between Jersey law and English law in the law of property, which operates differently, Jersey law does recognise equitable principles, does recognise trust law, and applies it frequently. And if it's helpful to have any citation for that, though it's well known to my lords, I would just quote the very well-known case of re-esteem, which is the very illuminating judgment of Deputy Bailiff Burt, which is to be found at Authorities Volume 13, tab 149, 24679, and I would particularly draw attention to paragraphs 83 to 87 at MS page 24709. But unless your lordships would like me to, I wasn't intending to go to that now.
Yeah, but when you say recognise equitable principles, it doesn't have a system of equity parallel to its common law, but in the context of trust,
Yes.
it recognises beneficial interest and differences like that.
It does.
But you can't dream up an equitable charge out of nowhere, standing Jersey's property law.
I think that's right. Well, and the lordships have them in the bundles. There are the Z Trust cases. I'll just give the reference in case your lordships want to look at them. Volume 29, tab 404, MS 30864, particularly at 30872, and also tab 28, this one I just, tab 394, page 30864, and have I given all three?
It won't be 30864, but it's tab 28, 394.
And tab 30, 29 at 404.
Yes, we've got that one.
And 13 at 155, which is MS 25062. And one of those cases does actually recognise that an equitable lien exists under Jersey law.
In the context of?
This is the case which followed the Court of Appeal's judgment from Guernsey in this case. Well, followed it in the terms of time. It actually says something different.
Yes, well, this is a trustee's lien, is it? Yes.
The trustees.
So this is
Yes.
all occurring in the context of a trust mechanism.
Yes. Well, it does. I turn to Miss Perkins, who, as lordships may or may not know, is qualified in Jersey and has practiced there for a number of years.
I don't think there's any dispute that in the context of trusts, certain equitable principles come in.
Well, I was just offering those observations simply in case it was of assistance to your lordship.
That is, thank you very
That's
much.
all. And in that context, my Lord Briggs referred to administration action. I I'm not sure I got the full correct answer. I'm not sure that's what it would be called.
No, nor am I. I'm afraid I was using an English heading
Yes.
for something which is probably recognisably similar in Jersey.
It would be an application under the supervisory jurisdiction of the court.
Yes.
And I only say it, not that it makes any difference to my argument, simply in case
Sounds
your
awfully
lordship
like an
wanted to know.
administration. Yes. Shorn of some of its historical rough edges.
And then the final point I wanted to make, I need to do this, it's not being referred to. I don't think, yes, all I wanted finally to do, because my learned friend didn't, as I understood it, make any submissions in response to what I'd said about Article 26.2 and reason to be incurred and so forth, so there's nothing for me to reply on. I did promise your lordships I would give the references to what we said about causation, so that's all I propose to do, if I may. It's to be found. It's to be found in our, as I did say, it's in our retrial case. It's at Appeal Documents, Volume 2, Tab 22, and Appeal Documents, Volume 3, Tab 50. But I'm sorry, on it's really that, isn't it?
Sorry, could you give us the...
Yeah, I'm going to give my lords a slightly... I know that.
Give us the pages, MS.
And I've given your lordships Volume 2, Tab 22, Appeal Documents, Volume 3, Tab 50, that's 14451, and particularly at paras 30, which is page 14464.
30?
30.
Yeah.
And paras 49 to 54, which is MS, pages 14472. And one final reference, that makes a reference also to the defence and counterclaim, and that's in the core bundle, tab 39, MS, pages 744 to 747. Was there any points I wanted to raise in reply, unless your lordships wanted me to deal with any particular point?
No, thank you very much. I think we've caught up, haven't we, in fact?
Well, I take credit for that, then.
Yes. We're now ahead of schedule. We're now ahead of schedule. So.
Well, I'm not sure about that, my lord.
I think probably about 10 minutes.
Anyway, we're obliged.
Right. Anyway, where do we go next? Yes, Mr. Equator.
It's my reply. Lord, I was going to, if I may, address Lord Sumption's private international law analysis that Article 32(1)A affects the capacity or constitution or status of the trustee. My Lords, in our submission, that analysis is contrary to the point decided by the House of Lords in Adams and National Bank of Greece. Now, that case decided, which I'll go to, that where a foreign statute, in that case a Greek statute, would have the effect of discharging or relieving a party of a contractual obligation, that would not be recognised as a matter of private international law unless the statute was part of the proper law of the contract. Now, the key point for our purposes on this argument, my lords, is that the status argument, the status of the Greek bank argument, was run very hard in the Adams case and was roundly rejected on the basis that it doesn't matter how the foreign legislation dresses up its statute. It may be a moratorium on debts, it may be a discharge in bankruptcy, it may purport to affect the status of the counterparty to the contract, as in the Adams case, the Greek legislation specifically framed the legislation to make the question of liability a question of the status of the Greek bank debtor.
You look through English, or through, in this case, Guernsey eyes, at how the law of the forum classifies the relevant instrument.
One does, but I would suggest, my lord, that the Adams case is quite...
I think you just ought to refer us to give us the reference.
Yes, well, perhaps I could just take your lordship to it briefly. The reason I go there is because we say that what Adams is saying is that...
Can we look at it? Where is it?
It's 2 at 26.
2 at 26.
Bundle 2.
Right.
Have you got an MS number?
The If I could just remind your lordships.
What's the MS number?
The MS number is 20538. And my lords, just
some of us are less familiar with this than others, I think. Don't assume that we all know what it's all about.
well, if I could just very briefly start there, and I do appreciate time is limited. But
Yeah, well, I'm afraid to say I was wrong a moment ago in saying we'd caught up. We are, in fact, 20
We are a
minutes
little bit
behind time.
yes.
Getting muddled with the times.
Can I have the MS number again, please?
The MS number, my lord, is 20538.
And the congratulations to Lord Goldsmith are also withdrawn.
That's,
I misread him as having half an hour, or having the whole of the rest of the time. Right.
I'm sure he is devastated. Just to remind your lordships, this is, as I think Lord Mance pointed out previously, this is the sequel to the Metlis case. And what had happened, just briefly to remind without reading the headnote, and you can get this in the headnote in the Metlis case, which for your lordships notes is at 24000 at bundle 11 at 127. In 1927, the Greek bank, the issuer, issued bonds expressly governed by English law, guaranteed by another Greek bank. The Greek government in 1949 enacted a moratorium on all obligations on the bonds. Then 1953, pursuant to a Greek statute, the guarantor and another Greek bank merged to form a new company, a successor bank, which was the universal successor to all the rights and obligations of the amalgamated banks. And then in the Metlis case, one of the bondholders sues in England successfully. House of Lords held that the successor bank was liable and the moratorium didn't apply because it wasn't part of the proper law. So the bondholder's claim succeeded. Then the Greek legislator had another go, and that's the Adams case at Bundle 2, tab 26, where in 1956, the Greek government passes another law, retrospectively amending the earlier law, so as to declare that from the time of its creation, the successor bank became the universal successor to the rights and obligations of the guarantor, except for the obligations under these particular bonds and the guarantee of these particular bonds. And the successor bank attempted to argue that it had acquired these liabilities as a rule of its status under Greek law. And it said Greek law that had the power to remove those liabilities by changing the status of the bank. And that argument was rejected because the House of Lords determined that Greek law could not discharge an English contractual obligation simply because the Greek legislator chose to characterize it as something to do with the bank's status. And if one looks at the report itself, at MS2...
But the critical aspect of that, presumably, was that it was doing so after the liability in question had accrued. It therefore had to be regarded as a discharge.
Well, I would suggest, my Lord...
as a constitutional status issue.
My Lord, I would suggest that it isn't the timing point. As we'll see from the judgments, I think Lord Reid specifically refers to the fact of even leaving aside the question of
If the headnote's any guide, there were differences of nuance, and some of them attached more importance to the retrospectivity element than others did.
Well, Lords, could I take your lordships to the speeches, just to try to make good the point? The argument that was run by the Greek bank, it's recorded at 20549. Where one sees just in the first full paragraph, second line, if in Greek law, this is a record of the argument being put to the House of Lords. If in Greek law it affects the status of the respondent bank, that's a most material consideration under English private international law in determining whether or not it is a law relating to status. The only authority which is of assistance is Metlis. That case decided, one, the proper law to determine the status of a Greek company's Greek law, and two, status includes attributes, that is, the rights and duties attributable to the status in question. So that's the argument being put. It's also the same argument. The argument is recorded at MS 20553, top of the page, in internal numbering the report 270. In the first full paragraph, there's still the argument. In conclusion, the whole basis of the Metlis case was the enforcement of a right under a Greek statute. And the statute is a perfectly general law of succession, etc. But it is not so much a question whether it falls in the category of a law of succession as whether it deals with the status of the Greek corporation. The Metlis case held that the act was an act concerning status, and therefore it follows that since part of that act was repealed, it is itself a law of status. So it was very definitely a status argument was being put, and one can see how Viscount Simmons addressed that on 20556. He understood the argument to be one of status. One sees in the bottom half of the page, the penultimate paragraph, starting from about 7 lines in, it was said that in the Metlis case, the English court affirmed the liability of the respondent bank under the Act because it recognised the status of the new bank as the universal successor of the old bank. This was a question of status, and if the status was changed by Greek law, then the obligations originally imposed would change also. The status, so the argument proceeded, was in fact changed by the Act, which purported to absolve the new bank of its former obligations. Therefore, the new bank was no longer liable. He rejects the argument over the page at 20557, foot of the page, picking it up about a dozen lines from the foot of the page. It's upon the reiteration of the blessed word status that the respondents rely. The obligations rested on status, the status was altered, the obligation disappeared, in fact, was never there. My lords, I doubt whether anything is to be gained by debating whether the act should be described as activating status or an act discharging contracts. Give it what label you will, its effect is that it purports to relieve the respondent or bank of a liability, thereafter enforceable against it. And for my part, I should not hesitate to say that the principle of private international law in regard to discharge or alteration of a contract is applicable whatever device of nomenclature is used. If the effect of a challenge decree is to discharge the or alteration of contractual rights. And if you would permit me...
Well, now that reasoning does appear to depend on the fact that there was in being an existing accrued liability, which the substantial effect of the new rule was to abrogate, which is not the same as contracting with an outfit that already has the relevant status.
Well, my lord, the Lord Reid, when he addressed the status argument at 20565 to 6, he recites the status argument that Greek law had destroyed the respondent's status as regards the appellants at 20564, the second half of the page. And then over at 20565, foot of the page, Lord Reid, in the last few lines, says the effect of the law, leaving aside for the moment its retrospective character, was the same as if it had merely discharged these liabilities. As I've already said, it's well settled that English court cannot give effect to a foreign law which discharges an English liability to pay money in England, and the appellant's contracts were English contracts under which they were to be paid in England. So unless the form of a foreign law is more important than its substance, the Act must be treated as a law which seeks to discharge English liabilities. It cannot therefore be effective in England. My judgment must look to the substance and effect of a foreign law, and that's a question of fact. Now, my lords, I would suggest that it isn't a solution to say it's all about capacity removed in advance, as if the contract was never made. The rule in my submission isn't dependent on timing. I would suggest that when one comes to the characterization question, a useful starting point is to consider what the position would have been if the Act, if Article 32 did not exist. The statute did not exist at all, because this is a situation where a trustee, be it individual or corporate, does have a personal capacity under Jersey law. One can see that acknowledged in Article 32(1)b, which specifically refers to the personal liability of the trustee and acknowledges its existence. And we've seen what the common law position is. So we're not dealing with a situation where the contracting party has no personal capacity under the general law to contract. We're not dealing with a situation where, for example, a company a contract might be ultra vires a company which never had any capacity to enter into the contract. A trustee does have a personal capacity, but this Act is purporting to take it away. Now, in relation to these liabilities. Now, in my submission, what Adams is saying is that however you dress that up, if the substantive effect is to discharge the liability, it won't be recognised unless it's under the proper law of the contract.
What would have been the position if the original Greek legislation bringing about the merger had said they are to succeed to all the rights and liabilities of the previous entity minus the 1927 bonds. Now, there would then not have been a universal succession, and the result of Metlis would have been different, and the result of that, and Adams wouldn't have arisen.
Well, what one's dealing with then is how would the English court have looked at the prior legislation? Would it have categorised that as a question of status or capacity?
But if the successor entity had never taken over the liability in question, there would have been that would have been perfectly recognisable in England. The problem was that they did have it, and then they purported to shed it.
Well, it may be that the English law could take a different view to a status statute, a capacity statute, like that which was a pre-existing statute. Now, that is possible. But ultimately what we're talking about here in my submission is how do you characterise this issue for the Raiffeisen purposes and PIL purposes? Do you characterise it as an issue of a trustee's capacity to contract? Or do you characterise it as an issue of the discharge of the contractual obligation?
Well, it could be neither, because it could be that what is being created is a concept under which a person contracts in a limited capacity only, and that might well be part of the constitutive law of the entity in question. That's a third possibility, which is the one I think, certainly as far as I'm concerned, that you need to address.
Well, it's still a possibility that relates to the capacity or constitution of the entity.
No, it's nothing to do with capacity. It is not in the sense you're using. It's nothing to do with the question what kind of liabilities the entity is capable of taking on. It's concerned with capacity in the different sense. In what capacity of two available is this person contracting, and are we to create a situation in which you don't simply stop at identifying the natural person, you also subdivide a natural person into two different capacities? Now, that is the target that you've got to aim at, I would have thought.
No, well, I understand the analysis of separating capacities on the part of the trustee, my lord, but it's still a capacity question, because one's trying to draw a distinction between acting in one capacity as trustee and acting
I see.
in
In that sense, I can see that.
And if I would respectfully suggest, if one looks at the statements made in the Adams case about what doesn't matter what device of nomenclature you use, it doesn't, and it doesn't even matter if you say the obligation was never there in the first place. They were not prepared in the House of Lords in that case to say that overrode the private international law rule about contracts. Now, that in our submission is a strong steer that this issue before us should be characterised as one of obligations and not one of capacity. My lord, perhaps I can just add to that in our submission, there's nothing in the language of Article 32 which indicates that it was intended to create a new and unusual legal status for a trustee, because both, it's at 20430, as we know, both A and B under 1 apply where the trustee is acting as trustee. Those are the words that are used. And what changes between 1 and A and B is not the status or capacity that the trustee is acting in. What changes are the consequences where the third party brings a claim. Is what changes. So if you have the unknowing third party in B, he can bring a claim, it says, against the trustee personally. That doesn't mean he's entered the transaction in a different capacity. But A uses the same words. It also says you can bring a claim. The claim by the other party can be brought. And in that case, it says against the trust property. So in our submission, the sections don't focus on capacity of the trustee to engage. They focus on what the claim can be made against and who the claim can be made against. So in our submission, the language of the section doesn't lend itself very easily to a capacity analysis. The I should perhaps add that if one is creating a new and distinct personality for the trustee separate from the trustee's other personality or personal capacity, you would expect the new capacity to have both rights and obligations, because you can say, well, the obligations are created by 32(1)(a) because you incur the obligations under 32(1)(a) to knowing creditors. But if you ask yourself, well, what rights does this new capacity trustee have that one is perhaps thinking about creating? Because supposedly under A, one is to have a remedy against the trust property. The remedy for the creditor is to the trust property. Now, this separate personality trustee doesn't own the trust property. The trust property is held by the trustee personally. And it doesn't, in fact, trust property doesn't even vest automatically in a new trustee. It has to be transferred. That's Article 17.4 of the Trust Jersey law. So, and we know that in this case, the former trustees, the property remained vested in the trustees for a long time after there was a change of trustee until the receiver was appointed. So you've got an odd situation where you have created some kind of species of capacity of an entity that has obligations and no rights, or not evidently any rights, and which, now, of course, it's a legal fiction, so one can, in a sense, the legislator can do what it wants on a legal fiction. It can create whatever fiction it decides to create, as the Greek legislator did in the Adams case, but one is left with, in my submission, quite an odd situation where you have a new and, in fairness, when your lordships challenged my friend Mr. Tubb to identify a parallel in private international law context, I don't think any satisfactory parallel has really been identified. And I should say it's different from what we say. When we say you are sued under A in a representative capacity, what we mean is a procedural device under the rules of court to ensure that the trust and all those who are party to the trust are bound by the proceedings and the judgment therein. It's not creating a new capacity in the sense, I think, that your lordship is proposing. Now, that's what I wanted to say on the capacity point, my lords.
Could I check you on one point? You say that it has obligations but no rights. I wonder if that's right, because if the obligations of the trustee, qua trustee, are in respect of the trust patrimony, then presumably if the trustee, qua trustee, has claims against a third party which belong to the trust patrimony, he can set off his claims against the obligations. So,
well, my lord,
there will be rights as well as obligations, won't there?
well, not necessarily. It depends. None of this has been worked out, as it were, because...
I don't understand why you say there can be, by the separating of personalities, there can only be obligations and not rights.
Yes, the person who has the office of trustee doesn't have a cause of action. You'd have to assign it to a new trustee. So these rights and obligations don't move with some office or representative capacity of being a trustee. They move individually with the trustee and the trustee's personal capacity. In our submission, it doesn't seem to us coherent that the same subsection gives a right to proceed against trust property, which will be vested in the trustee necessarily in a different capacity. Now, my lord, I'm not pretending that in a sense, legislators can do what they decide to do, and could decide to create an entirely novel division of capacity in this way. But in our submission, it doesn't fit with the section, and I would suggest it's contrary to Adams. Perhaps I could just say this, there's nothing in the legislative materials that have been cited around about the enactment of section, Article 32, which suggests that such a radical change in capacity was intended, and it's not been held, as far as I'm aware, to be the effect of equivalent legislation in other jurisdictions, and one is a little bit nervous that if one creates this new type of capacity, there might be tax implications, regulatory implications that have hitherto been not been foreseen. And given that in my submission the article doesn't look like a capacity section, you have the position of creditors who have contracted with Jersey trustees, not understanding this section to be a capacity section and thinking that their obligations are protected under the proper law. Now,
quite a few countries have enacted something like this, but presumably every trust jurisdiction would immediately enact an equivalent. Trustees would be on the spot and saying, this is exactly what we want. It'll cover all our contracts without us actually having to draw attention to it in our contracts.
Well, quite. But
that's exactly what happened over the recent legislation on limited partnerships. Jersey introduced legislation allowing limited partnerships, faced with the prospect of large numbers of migrant partnerships. The UK government promptly introduced a souped-up version of the same legislation, yes. And other jurisdictions have done likewise. Yeah. So this is life.
Well,
does it have equivalent consequences?
Well, it creates a separate legal personality in the partnership, which is what the 1907 Act conspicuously didn't do.
Well, perhaps I'm conscious of the time.
Well, I think we're now running in negative time. I'm sorry. Even allowing our 20 minutes.
What was going through my mind in that debate was, what if you get some unscrupulous states who try to absolve their entities of liability by enacting legislation which purports to affect the capacities of its entities?
No, I think we got the point.
Yeah. That, now, my Lord, the last point I want to make, and then I will sit down, is to address my Lord Mance's point that maybe the section only does one thing. Maybe it just absolves personal liability and doesn't do anything else. My Lords, in our submission, it must do so, because Your Lordship has our submission that if it absolves personal liability, there is no requirement to rely on the indemnity in A. The indemnity becomes irrelevant because the trustee isn't suffering a loss for which he needs to be indemnified. And therefore, it is a pure statutory right of access to the assets, as it were. If you contrast that with B, where the personal liability and the indemnity are specifically identified, those are dealt with differently, and in our submission for a reason. Because in A, you have a less impeded access to the assets. And as a matter of
you're
policy,
assuming that A is read like that. I mean, I wonder. This is dealing, as you pointed out a moment ago, with the third party's position. What is our liability to a third party? And on one reading of A, all it says is a claim is against the trustees and extends only to the trust property. That doesn't necessarily give some in rem claim against the trust property. It could just mean that it's shorthand for saying extend only to the value of the trust property.
my Lord, I'm not suggesting for these purposes it provides an in rem claim, but what I'm suggesting is it provides a claim that is not impeded by a breach of trust claim against the trustee.
You are saying that is what it provides?
Yes, I do say that's what it provides. It provides a recourse to the trust assets unimpeded by any breach of trust claim, because it's not a question of enforcing the trustee's indemnity under A. That's B situation. And the reason, and as I mentioned in I think my opening, that if the legislation distinguishes between two categories, it usually does so for a reason, and it has done so here. And you contrast that with the express right to rely on the indemnity in B, which refers to the indemnity and to personal liability. The other point is the policy point. There was some debate yesterday about whether this would make Jersey an attractive trust jurisdiction. Well, if you remove the creditor's ability to claim against the trustee personally, as most in this room seem to think that 32(1)A does, but you do not, as a quid pro quo, give the creditor improved access to the assets, this is a one-way anti-creditor piece of legislation.
But the creditor can get around that very simply by taking security.
Well, Miles, the security implications are not as easy as that. I know there was a share charge.
Take specific security over an asset.
Well, we've cited in our written submissions that there are practical difficulties, and this was gone into in Professor Hayton's paper as well. There are practical difficulties with floating charges created by trustees. Fixed charges, there usually is a power under the trust deed, and they seem to be recognised, and there was a share charge in this case. But floating charges create difficulties, and Lewin goes into this as well. And the difficulties are they get overreached, they don't necessarily bind a successor. There's a question of what about distributions to the beneficiaries? Do those take precedence? Those are all issues that the trust lawyers have been grappling with. So it's not a straightforward...
You have to take a fixed charge.
Well, a fixed charge is not necessarily very easy to, as a matter of business, to get on with the trust business, because in this case, the trustees were dealing with contracts for differences and in the financial markets and so on. And one can't really take fixed charges that are going to give you very good protection in those kinds of circumstances, because the assets have to be available to be used.
We surely have to look at this question of interpretation right across the trust board, as it were.
Yes.
And the fact that we're here dealing with an extraordinarily highly leveraged business involving
Yes.
contracts for differences and derivatives and
Yes.
God knows what else, in which bank lending was attracted on terms which originally included the principal beneficiary's personal guarantee.
Yes.
Shouldn't blind ourselves to the perhaps more typical situation in which a Guernsey or a Jersey trust is set up, in which there may be some borrowing by the trustee, but which is unlikely to give rise to the sort of difficulties of security, for example, that arise if the trust's carrying on a derivatives business.
I quite take the point that in an ordinary case, if there is such a thing, a fixed charge might be satisfactory security. But one has to also recognise that in this day and age, that trusts, particularly offshore trusts, are used to invest in financial markets, as this one was, and to get involved in exotic instruments, trading of all kinds, as we saw in this case. And the legislation obviously has to be capable of, has to be capable of accommodating that. And I'm simply pointing out that...
Well, I think this is a bit difficult, because I think in 1984 derivatives were nothing like they are now, and it may be that it didn't think of the particular problem.
Although the section was amended in 2006, and that's just before the financial crisis.
Yes, I see.
Yes. My Lord, I've overrun my time.
Thank you very much. Right.
Assist further.
So we now turn notionally to Wednesday morning. Being already there, I think, yes, it's Mr. Taub. Contractual limitation, yeah.
This is the former trustees' cross-appeal on the construction of the loan contracts which existed between the former trustees and two of their subsidiary companies, Thorson and Glenalla. And we've set out our position in our written case for the cross appeals, which was...
We just see that.
It's at MS 13897 to 13914, and in the appeal documents it's volume 2, tab 24. It's different. Most of our submissions are in a large omnibus document which deal with Article 32, restitution, costs and so forth.
Yeah.
This was our cross appeal, and so this is in 224, as I say. And we thought that the Court of Appeal had decided that on the true construction of these contracts between Thorson and Glenalla on the one hand and the former trustees on the other, that the former trustees were not intended to be personally liable, but only liable as trustees to the extent of the trust property. And that one finds at MS 17 and 18 in the June 2014 judgment. It was dealt with in about 6-7 paragraphs.
Yes, quite.
117 to 121. But when they came to make their order, they said they hadn't so decided. So I have to address your lordships on the footing that I need to persuade your lordships that as a matter of construction, there's no intention the trustees should be personally liable. It's contemplated they'd only be liable in their capacity as trustees to the extent of the trust property. Your lordships may or may not be aware that there were no formal written contracts. This was not a case where lawyers drew up commercial contracts between the trustee and its subsidiary. There was no evidence of oral offer and acceptance. What happened at the trial was there was an issue as to whether or not these contracts existed at all. And ultimately, the learned Deputy Bailiff concluded, on the basis of such documentary evidence as there was, that there had been contracts. And so contracts were inferred from a course of dealing. And the Guernsey Court of Appeal reached their conclusion that the trustees were not intended to be personally liable as a matter of contract on the basis of really two sources of evidence. First of all, they relied on the evidence of Mrs. Lydia Bleasdale, who was originally called Miss Peck, and she married after the relevant events and became Mrs. Bleasdale. She gave a witness statement, principal witness statement, about the entire course of events, in particular the way in which first of all, the Cengiz Family Trust operated, and then the Cengiz Discretionary Trust operated. All the money that was lent by Thorson to Investec Guernsey Limited, I'll call it ITGL, was lent prior to August 2007, all the 80.5 million. All the money that was lent by Glenalla to ITGL, was again prior to August the 20th, whenever the assets were appointed from the Cengiz Family Trust, the Cengiz Discretionary Trust. So the original transfers of funds all occurred in a period from about late 2006 to mid-2007. And the way the transfers occurred was that there were requests rather from the investment advisors, R20. R20 is a company of which Mr. Robert Cengiz, the principal beneficiary, was the chairman and a director. And they made recommendations about investments to the trustees and to the trustee underlying companies. And then employees within the Investec organization would give directions to the banks to make transfers from the underlying Glenalla and Thorson company accounts to an account called the TFT account. And there would then be resolutions, some cases, but not always, by, on the one hand, the company shareholder, and on the other hand, by the trustee expressly as trustee of the relevant trust, in this case, the Cengiz Family Trust. And so all those loans were in place prior to the appointment of Glenalla and Thorson by the trustees of the Cengiz Family Trust to themselves trustees of the Cengiz Discretionary Trust. Now, you may have picked up that the trustees of the Cengiz Family Trust there was one trustee, ITGL, and the Cengiz Discretionary Trust, when it was funded in August 2007, was ITGL plus another subsidiary which is called Bayer Trustees Limited. And it may be that one of the reasons that had to be done is because of the rule that you can't contract with yourself. But I'm not entirely clear about that. But anyway, what happened was that when ITGL, as trustee of the Cengiz Family Trust, appointed the shares in many companies, including Glenalla and Thorson, to be held on the terms of the Cengiz Discretionary Trust, the existing debts were novated. That's to say, ITGL and Bayer were substituted as debtors in place of ITGL as trustee of the Cengiz Family Trust. And when we come to look at the documents, you'll see that it's made clear it's being done in the capacity of trustee of the trustees of the Cengiz Discretionary Trust. They were taking over the liabilities of the trustees of the trustee of the Cengiz Family Trust. Throughout, it was made clear they're acting in that capacity. And I'll show you the document in a moment. The terms of the deeds of novation really did no more than substitute the ITGL and Bayer as debtors in their capacity as trustees of the Cengiz Discretionary Trust in place of ITGL as trustee.
Well, no one's suggesting that the novation makes any difference to the outcome of this.
My Lord, I'm very grateful. That was the point I was going to come on to. That no one's suggesting that because the point is the deed of novation didn't change the underlying terms of the debt contracts. So the Lieutenant Bailiff and the Guernsey Court of Appeal both approached the matter on the footing that one needed to understand what one could infer about the intentions of Thorson and Glenalla on one hand, and the trustee of the Cengiz Family Trust on the other in 2006 and 2007. What could one discern from the fairly exiguous evidence in this course of dealing? And so for this purpose, we thought it helpful just to give you a snapshot of the documents that the Guernsey Court of Appeal looked at to reach this conclusion. It's possible that you have these documents electronically already, but just in case you don't, could I please hand up?
Is this the table?
This is the table.
Yeah.
Can I?
The usher will do it.
Thank you.
The usher will do it.
Yeah, sorry, I thought you'd been given them. I'm very sorry, I was told you'd been given them.
No, I've got two.
You have one more, please.
Thank you.
It's the electronic version called the Thorson and Glenallan's loan table, isn't it, or something like that? Yes, I found it.
Now, Lords, I'm not going to go through all the documents. You'll be relieved to hear. Can I just take a couple of samples of two loans to show what happened, so your Lordships can see the pattern? And this is the exercise that the Court of Appeal went through. Can I deal? You'll see the first loan referred to there is a Thorson loan of £13 million. And if you go to MS 2917, which is in volume 3 of the record.
So sorry, could you give me that page again?
It's 2917. Your Lordships have that. It should be an email headed David Roussel from Lydia Peck.
Yeah.
Lydia Peck was the employee. I should explain who she was, what her role was. She was an employee in the offices in ITGL in Guernsey. Thorson had, although it was a BVI company, it was administered by corporate directors. I think it was Finisterre. And the employees of Finisterre included Miss Peck. So she was, so to speak, on both sides of the transaction. And this is a direction that she was giving to someone else in the Investec banking group, I think, Mr. Roussel. And it says, Thorson, payment request for today. David, can you please prepare a fax instruction to Kaupthing to transfer 13 million from Thorson to TFT IBCI account. TFT is the Cengiz Family Trust, so the intention was to transfer to a trust. And then Tracy is someone called Tracy Walker, who was another employee who worked both in the administration of the Thorson Company and also in ITGL. Tracy, can you prepare resolutions re-loan payment from Thorson to TFT? This is off the back of my conversation with Tim Smalley at R20 today. R20 were the investment advisors of Mr. Cengiz Khan. Tim recommends we transfer money from Kaupthing to IBCI, I think that's Investec Banking, Churchill Islands, as we are very low on funds. So that's a fairly typical way in which these transactions operated. Came from a request or a recommendation from the R20 investment advisors. If one goes back a page to 2916 on the electronic, one sees that this is the instruction from Investec, from Mr. Roussel to Kaupthing, asking for Thorson to transfer £13 million. And if you see the debit reference, it's described as repayment of loan to shareholders. You may think that's rather an odd way to describe a loan, but what had happened was that sort of a running account. And for a long time, Thorson had been in debt to the trust. And so payments had been made in repayment of that debt over time. But by now, the position was that the Thorson was actually lending money up to its shareholder, the trustee of the TFT. And that nomenclature continued, although it wasn't appropriate, and it probably just reflected a practice that had existed beforehand. If one goes back the previous page to 2915, one sees the Kaupthing's record that the payment was actually received, 13 million client Thorson, and there was a transfer, that was actually paid. And then if one goes back to...
what was the basis on which Thorson was simply able to effectively draw down from Kaupthing?
Well, it was... it may have had a deposit at Kaupthing at that time. It had a facility too. It had a very large facility of about £1 billion.
And the mandate enabled Investec to direct what happened with...
I think that, yes.
Must have.
I think that's right, how it worked, yes. And then, if one goes back to 2912, one sees how Thorson dealt with it as a matter of company resolution.
It wasn't a partial loan repayment at all.
No, it was by the stage, it was a loan.
Full-scale loan.
Yes, my lord, yes. But your lordship will see that it's described as loan repayment to shareholder. So there's no suggestion that it's looking personally to ITGL in its personal capacity.
Well, I suppose they may have thought it was a loan repayment, because without going to the running account,
exactly,
they might not be able to tell.
Exactly. And I'm going to make the point in a moment that the ledgers were only made up sometime afterwards, often, and so sometimes they couldn't always tell. And there was a lot of activity on these accounts. You'll see that
Sorry, what significance do you attach to the word shareholder? It shows...
So it doesn't describe a specific person. It doesn't say ITGL. It doesn't say ITGL in its personal capacity.
No, but it doesn't say not in that.
Exactly. It doesn't say anything about it, is the point, my lord. And your lordship will see that the resolution was signed by Tracy Walker and Lydia Peck, who were employees of ITGL, and the individuals who carried out these or who administered these transactions. And then if one goes to 2913, one sees the other side, one sees the trustee resolution. Investec as trustee of the Cengiz Family Trust, so it was as trustee that it was executing this. It's resolved, it was said, to accept a partial loan repayment of 13 million from Thorson. And again, executed by the identical people, Tracy Walker and Lydia Peck, who are employees of ITGL. So this is an internal transaction, we say, carried out by the same people at the direction of R20 from a shareholder up to a shareholder from its underlying company. Nothing said expressly one way or another about personal liability. And then if one goes back to 2905, I'm afraid it says 2906 here, but I think it's 2905, one sees how it's dealt with in the ledgers of the trustee, and it's headed a shareholder loan, Thorson Investments Limited. Top right-hand corner, simply Cengiz Family Trust. And if one goes to the entry 1, 2, 3, 4, 5 up from the bottom, one sees a date, 13th of December 2006, value 05/12/2006, Kaupthing Bank, Luxembourg, loan repayment from Thorson, and then one sees the 13 million. Does your Lordship see that?
And the balance,
It had been in...
so previously the balance was what, in credit to the trustees, and then went to a small debit.
I think that's
So it was in fact a repayment, say it as to
a bit.
about £1 million.
Yeah, and then one goes on, one sees that the story develops. They continue to use the phrase loan repayment. So this is the trust ledger, and the point was made in the evidence of Ms. Bleasdale that the ledgers were often made up sometime after the event.
So it appears.
And in the, I don't think we need to go to this, but in the Thorson ledger, it simply appears, as you can see from the summary here, loan repayment to shareholders. Can I just give one other example of how this is done, just to show kind of pattern? I think this was also shown to the Court of Appeal. If one goes to page 3 on our little table, one sees 23rd of March 2007, 20 million was lent by Thorson to ITGL. And one finds that I think for present purposes, the Learned Juniors summarised the evidence that existed of this loan. I don't think we need to look at the first item, which is described as a spreadsheet prepared for ITGL meetings. But one then sees the second is ITGL fax to Kaupthing, transfer request unsigned. And there one finds that in MS 2932. So here again, one sees this is the direction from Investec to Kaupthing, again referring to Thorson. The amount of the transfer request was 20,000. It was to go to an account name in the Investec Bank Channel Islands Limited. And again, it was described as repayment of loan to shareholders, and it was contemplated that it would be signed by the directors, the corporate directors of Thorson, although it doesn't appear to have been in this statement. And then one sees the resolution by the company is at 2929, again exactly the same style as we saw on the previous occasion. Thorson Investments, resolution of the directors, 23rd of March 2007, resolved the company shall make a loan to the shareholder.
At this stage, they've tumbled to the fact that it's not just a repayment.
Such loan being unsecured, interest-free and repayable on demand, yes. And you'll see that that Tracy Walker and Lydia Peck signed the resolution on behalf of Thorson. And then if one goes to the next page, 2930, one finds the trustee resolution. And this says Investec Trust Guernsey Limited as trustee of the Cengiz Family Trust, the trust, trustee resolution, 23rd of March, loan from Thorson Investments Limited. It's noted that Thorson Investment Limited have agreed to loan the trust. So that's how it was viewed. It was seen as a loan to the trust, not to ITGL in its personal capacity. The sum of 20,000 on the date hereof, such loan being unsecured, interest-free and repayable on demand, and it was resolved to accept the loan. And the signatories, although it may not be easy, but you can go back a page, are again exactly the same people who signed on behalf of the company, Lydia Peck and Tracy Walker. So that was, there are other examples if you wish to go through them later. We've given them in this table. I don't propose to do so, but that indicates the style of how these transactions occurred. They weren't always resolutions because of the speed with which things had to be done. Now, I ought to, though, take you to the deeds of novation briefly. Again, I'll focus on the Thorson one. You find that in the MS 469. That's in the core bundle, volume 1. And your Lordships will see the frontispiece dated the 24th of August 2007. One, Investec Trust Guernsey Limited, in its capacity as trustee of the Cengiz Family Trust. And two, Investec Trust Guernsey Limited and Bayer Trustees Limited, each in their capacity as trustee of the Cengiz Discretionary Trust. And three, Thorson Investments Limited, deed of novation. So stating on the face that they were transacting as in their capacity as trustees.
Yeah, yes, I mean, this is obviously all going to end up with the submission that this is sufficient, is it? Because if so, it would probably be sufficient in it only makes sense, though, in the context of the Jersey law, does it, that a trustee is limited?
Well, I think we would say that put the Jersey law to one side.
This arises on the footing that you're
wrong on that. So
yes.
We say that every time this formulation is used, it's sufficient to remove the personal liability of trustees.
My Lord, I hope it's a slightly more nuanced submission. I would say one has to approach. I will make my submissions on the law in the moment, but what I would say is this. One has to look at all the circumstances in which the contracts arose to ascertain objectively what the parties intended as regards the question of personal liability or merely representative liability.
And the Court of Appeal regarded as decisive not the use of the words as trustee, on its own, but the fact that this was all a top-down, centrally directed system in which there were no arm's length transactions at all. Is that how you put it?
Well, it's a my submission is that one has to look at all the circumstances.
But which are the decisive circumstances in this case? What should we be looking for when we go through these documents as representing the decisive factors?
What one's got to ask, looking at in the context of an informal arrangement of this kind, what can one objectively infer about the intention of the parties? And one can point to a variety of things. First of all, the point your lordships just mentioned. Secondly, the fact that there was no independent consideration on either side about the strength of the covenant of either party or anything like that. It was seen as an internal arrangement between shareholder and its owner. Thirdly, that there was never, unlike in the case where ITGL as a trustee contracted with outside third parties, there was never a formal contract and terms agreed and negotiated. Fourth, the fact that the way in which the transactions were booked was in the ledgers of the TFT, always, never in the ledgers of ITGL personally. And both parties, on both sides of the transaction, were aware of that.
So they were effectively treating this as if they were separate corporate entities.
In effect.
So that the intention must have been to do the nearest thing to that you can do without being a separate corporate entity.
My lord, yes. And the fact is that if one looks at the balance sheet and the statements of account of ITGL in its personal capacity, these matters are never recorded on its account. These debts don't appear on ITGL's balance sheet or in its statutory accounts. And that is evidence, we say, of the intention of, since the same people were...
So Miss Pack's intentions are everybody's intentions?
Well, she was acting under instructions, obviously, from those above her within the ITGL organisation. But that's how, as a matter of policy, they dealt with it.
What are we actually looking for? An implied term?
No, my lord, currently we're focusing on what you can infer about, in the absence of any statement, one way or another, about what the parties intended.
There wasn't a contractual intention? There was a contractual.
No, we accept there was a contract. There's no appeal on that point.
I'm sorry, I'm being very dim. I'm just trying to understand what it is we're trying to find.
But we're being asked to construe the absence of any statement, which I find might push one towards an implied term.
Well, it sounds to me as if what you're suggesting is a gap-filling term, which of the sort considered by Lord Wilberforce in Liverpool City Council and Irwin, which isn't exactly an implied term. What you are asking is, there is a gap. What must have been intended as the filler?
My lord,
contractual concept.
Well, this is over the years. There's been a sort of. Sometimes it's been suggested these exercises are the same. Sometimes it's been suggested they're two entirely separate exercises.
If you've got a contract effectively made by conduct, then implication may not be the right word to use to describe the process of interpreting the conduct.
Yeah.
Which is why I think I used the word what one infers from all the circumstances. And I would...
We do have the... I mean, it is made by conduct, but we do have the matching resolutions on both sides, I suppose.
My lord, yes, we do.
Which we gather that it's interest-free, unsecured and repayable on demand. You say we also gather it's made to the trust. So I suppose insofar as we're conducting in separate compartments, insofar as we can get our minds around it, construing the express term and then looking to see if there's anything to be implied, those might be said to be as near as you can get express terms since they appear in both sets of resolutions.
Those bits, yes, I follow that, yes. Yes. But
I mean, perhaps, well, where in your printed case can I find the best formulation of what it is you think we're looking for? Sorry, I'm just...
Well, I mean, I'm just looking at the underlying authority which you rely on, and maybe some other Jersey authority or Guernsey authority, but Lumsden and Buchanan, a trust where there was a contract made as trustees, it was asserted that meant we're not personally answerable, to which the Lord Chancellor said that that's not good enough. A trustee may so limit and restrict any contract he may enter into as to exclude between himself and the other parties to such contract personal liability, but this must be the result of express stipulation, and whether this be or be not the effect of any particular contract is a question depending on the construction of the instrument and the nature of the contract. So, I mean, he seemed to... He put it pretty high against your proposition.
well, my lord, I'll have to deal with the authorities.
Yeah.
What we're submitting is that there is no special rule of the construction of contracts between trustees and their underlying...
Very para 60 of your case.
And the true test we suggest is the one finds at... in the speech of Lord Cairns in the Muir case. All right, my lord, if before I take your lordships to the authority, I think it's important to understand what Muir and Lumsden are about. They're very special cases. The background in each case was that there was a bank carried on in partnership, and the partners, under the terms of the partnership, expressly had unlimited liability for the debts and obligations of the partnership. Subsequently, trustees became partners in the enterprise, and they, I think, signed in one case as trustees. And when the bank in each case became insolvent, it was sought to make those trustee partners liable along with all the others. And the trustees said, but we only contracted as trustees. Lord Cairns pointed out in Muir that that would have been repugnant to the very contract which they were adhering to, they were joining in. And the directors of the bank simply didn't have power to allow them to join on the basis that they had limited liability, unlike every other partner. So that was actually the ratio of both cases. And there are a lot of statements made by the judges in the course of both cases about how one approaches these matters. But it must mention, if one goes to the Lumsden and, to Muir, one gets the statement of law which applies, which will be reminiscent to modern approach to interpretation of documents that have been expressed by the Supreme Court in this country. And the authority of Muir and Glasgow Bank is worth looking at just a bit more detail than has been done hitherto. It's at MS 23946. It's in the authorities bundle 126, I'm sorry. Lord Cairns, having stated the facts, page 355, said, "My lords, whether in any particular case the contract of an executor or trustee is one which binds himself personally, or is to be sorry, it's at MS 23964. That is the passage I'm reading from. Sorry. Forgive me. My lords, whether in any particular case the contract of an executor or trustee is one which binds himself personally, or is to be satisfied only out of the estate of which he is the representative, as it seems to me, a question of construction to be decided with reference to all the circumstances of the case, the nature of the contract, the subject matter on which it's to operate, and this was the key feature of both Lumsden and Muir, and the capacity and duty of the parties to make the contract in the one form or in the other. And then he says he knows of no reason why an executor, either on English law or Scotch law, entering into a contract for payment of a person who is free to make the contract in any form he pleases, should not stipulate by apt words that he will make the payment not personally, but out of the assets of the testator. And then he goes on to talk about possible differences between English law and Scotch law, and makes the point that the difficulties in England about getting a judgment on the goods of the testator as opposed to the goods of the executor himself. And so,
I see. Does he quote? He doesn't quote Lumsden.
He does discuss Lumsden later on.
Yes.
My lord, there's an important reference there.
He was the unsuccessful counsel in Lumsden.
It's not an unknown phenomenon even now. People to get their revenge once they get to the bench.
Well, he followed, in Muir, he followed the decision in Lumsden and felt there was no alternative. But he gave, interesting an example at page 361, it's at MS 23970, of a case where, depending on the context, the use of the words as trustee or as trustee only could be sufficient to indicate that there was no intention to create personal liability. And he refers to the case of Gordon and Campbell. And in that case, trustees borrowed for the purposes of their trust from Colonel Gordon of Cluny 7,000 and granted an inheritable bond over the trust property to secure the loan. They bound themselves as trustees as aforesaid to make the payment, and in the clause of warrandice of the land, they bound themselves qua trustees only to warrant at all hands and against all mortals. Now, this was exactly such a case in the early part of my observations, I suppose, might arise. It was perfectly competent to Colonel Gordon and these trustees to make any contract they pleased. Colonel Gordon might have insisted they should be personally liable, or he might have agreed that they should only be liable as trustees, i.e. to the extent of their trust funds. They professed in one part of the instrument to contract as trustees and in another as trustees only. And it was obvious that they meant in both places to contract in the same way. Further, if these words as trustees and as trustees were not introduced to limit liability, there was no other purpose in the deed which they could possibly serve. They are absolutely unmeaning if they did not mean that the trustees were not contracting as individuals. Under these circumstances, the Court of Session and afterwards this House held there was no personal liability against the trustees beyond their possession of the trust funds. Now, like any case about construction of contracts, it turns on its facts. But the exercise in our submission is the Court has to look at all the circumstances of the case and the words used and ask whether the language which has been used in what is undoubtedly a very informal context in this case was intended to create personal liability or merely liability in a representative capacity. And we say that looking at all the circumstances combined with a reference to ITJ in the Cengiz family trust resolutions, always doing so as trustee, there really is only one answer if one asks oneself objectively, what could the parties' intentions have been? It was simply that the trustees were acting in this representative capacity, and they were not intending to take on any personal liability, nor would their employees acting for the shareholders lending the money have contemplated that the trustee was taking on any personal liability. So if one looks at everyone who's involved, it flies in the face of reality to say that there was an intention to make the ITGL personally liable on its own balance sheet in respect of these debts.
There seems to be a singular lack of authority for the proper or of precedent for the acceptance of that submission, doesn't there?
Well, my lord, it's something which
none of the cases which were cited and examined, even the ones where he was leading counsel, are authority for the proposition. None of the cases cited in Muir. They all reach the opposite conclusion.
Well, Gordon Campbell reached the conclusion.
Well, Gordon Campbell is the one case.
Which is the House of Lords case, my lord.
One case, yeah. So, ought we to look at Gordon Campbell, or does it carry it any further than?
Well, I think the matter is usefully summarised. I'm not sure is it in the bundle? Yeah, but
What about subsequent authority then?
My lord, there are subsequent authorities that they're not in the bundle, but there are cases in England where use of the phrase "as trustees" has been sufficient to oust person.
I think it'd be helpful to see a model. What date is Gordon Campbell? It's probably
Gordon Campbell's 1840.
Yeah.
That's the earliest.
I'm going to Brown and Rysaf, which is a modern authority,
which is a Scottish, yes,
which is a Scottish case, but my lords. But it's not the case that there is a presumption of law that a trustee always contracts personally. There's no presumption of law to that effect. It's a question of asking oneself what was the intention of the parties, looking at what they've said and the background to what they've done.
Well, the starting point surely is that if somebody contracts as a debtor to repay on demand, that he's going to repay on demand from whatever assets, including his own personal assets, he has available to effect that repayment.
If he's an individual,
yes, but one is looking for some limitation of the otherwise ordinarily general liability on a contracting party.
Certainly,
if a contract is completely silent, contains no words of limitation of any kind, then one wouldn't find it easy, would you, as a matter of construction, to say that there's limited liability merely because the person happened to be a trustee?
If there's simply a contract between A and B and nothing either in the document or the circumstances known to both parties, one can, my lord, I follow that. But it doesn't follow from that there's a presumption where someone is known to be transacting as a trustee that he is transacting personally with the other side. And that involves a leap which the authorities in this country have never made. That's not what Lord Cairns was saying. He said one has to construe the contract in all the circumstances, looking at the subject matter, and obviously taking into account the background. So with respect, it's not a case that there is a presumption that where a trustee is known to be contracting with someone else, that he is automatically intended to be personally liable. It's like any other case.
Is that right? I mean, surely there must be, you can't just sort of throw everything up and say, well, do your best. There's got to be some sort of principle. And one starts on the principle that someone who contracts is personally liable, even if he's a trustee.
Well, if he contracts as a trustee doesn't tell the other party.
Yeah, but if
one
it,
can
the
quite
mere
say-
words as trustee doesn't in themselves limit his liability.
Well, it might or might not, I think, is what Lord Cairns saying. It depends on all the
I'm
circumstances.
not sure. It's quite clear that, I mean, in Gordon and Campbell, the words, we contract as trustees aforesaid to make payment of the loan and bind ourselves qua trustees only to warrant at all hands and against all mortals. You've got the word only there.
That's the key word.
And if you simply had, it seems clear on the authorities, if you simply have a contract saying we enter into this as trustees, that's not sufficient. So there must be some sort of underlying feeling that you need more. Isn't that whether you talk of a presumption or not? That's
It may be that one has to show something in the surrounding circumstances too to fortify the impression gained from the use of the word as trustees.
I'm not sure the impression that, I mean, if we said that merely using the word as trustees was the end of the matter, that would be, or even gave a prima facie impression, that would seem to me to be contrary to the authorities. You need something more in the sense of only, implying only.
My Lord, we're not asking you to make a finding that, as a matter of construction, the mere use of the word as trustees without anything else is decisive. We're not asking you to say it's the other way around, but what we're saying is we have got something else in this case,
I.e. what?
which is the surrounding
Yes,
circumstances.
but that's very unsatisfactory. I mean, any case has surrounding circumstances. It
Well,
can't
if
be
you
just
ask
enough to
yourself
say,
objectively, what were the parties likely to be thinking in these?
But that is not a very
Well,
conventional method of interpretation, isn't it? Isn't that approaching implication on exactly the wrong basis?
my Lord, I accept I overstated it there, but the purpose is to look objectively at what has been said and what has been done, to try to ascertain the meaning. What would the meaning be of, viewed objectively, of what they've done? And would a person looking at it objectively conclude this is a case where ITGL were contracting personally? And we say no. It's not just the fact that they were contracting as trustee and clearly contracting as trustee. This was just an internal arrangement. But
this internality I'm somewhat worried about. You mentioned as part of your descriptions of why it was an internal arrangement because it was a loan by a company to its 100% shareholder. But that wouldn't, in ordinary circumstances, imply any limitation on the shareholder's liability, would it? Because unless the company could show in its books that that was an asset which it could recover as against its shareholder, its accounts would be presenting a rather misleading picture.
I follow that point, but it's if one looks at the books of the entities here, and I use the word entities, what one sees is that these loans were shown as loans to the TFT, not as loans to ITGL. And that, we submit, is a material factor in deciding was this a case of it being, was it a case of it being tended to be a personal obligation of ITGL or not?
I wonder about that. I mean, the loans would have to be shown as part of the trust patrimony because the assets, the money received from the loans, was not something that the trustees owned. But it may be a separate question whether or not by obtaining those loans as part of their trust patrimony, the trustees incurred personal liability for their repayment.
Well, my Lord, we're leaving aside for a moment the Article 32 point.
Yes, oh yes.
And
this is purely construing the contract.
yes.
I mean, your real point surely is that the way that the thing was recorded suggested that they were approaching the matter on a basis similar to your hypothetically rejected submission on Article 32. They had contracted as if these entities had separate capacities, whether or not that was the effect of the law.
Yeah, that was looking at the entire factual matrix.
But it's very difficult to see how you could keep proper trust accounts without doing that, so that I suspect that you may prove too much.
Yeah.
I think that essentially was the point I was trying to make.
Well, Lord, I was asked a question about whether there are other authorities on it.
Yes.
And it's maybe a convenient moment to look at the Brown and Rysaf case.
Yes, that.
Which is in volume 4 of the authorities.
One.
451.
It's 21450, it starts. Unfortunately, there isn't a head note, but what happened here was that Rysaf was the trustee of a company's share incentive scheme, and the company made loans to employees of the company to enable them to purchase shares. And the trustee, Rysaf, lent money to Mr. Brown to enable him to purchase shares. And then in that contract, it was provided that there would be an indemnity to Mr. Brown if there was a tax charge as a result of the grant of the shares. Because obviously he was an employee. And there was ultimately a tax charge, and Mr. Brown sought to enforce the indemnity against the trustee personally. Now, the documents did not say that, the loan document did not say that the trustee was not contracting personally. There was no stipulation in it to the effect that the trustee was not to be personally liable. But it was clear from the document that it was transacting as trustee, and it was part of this share incentive scheme. And the learned Glenalla, the discussion one finds at 21461. He says, it's paragraph 22, 21461. Even without a detailed analysis of the loan agreement, it's clear, in my opinion, that the defender was contracting as trustee of the trust. The overall documentation makes this clear. The loan was being advanced to the pursuer, that Mr. Brown, pursuant to the company share incentive scheme administered by the trust. In terms of that scheme, the trust was to acquire shares in the company and sell them to employees of the company, advancing loans to those employees for the purpose of enabling them to purchase shares. The award agreement and loan agreements with individual employees were an implementation of that share scheme. The award agreements confirming the number of shares to be awarded to the employee and the price the employee would have to pay, and the loan agreements providing for a loan to the employee, the price payable. In entering into the award agreement and loan agreement with individual employees, the defender was clearly acting as a trustee of the trust, which formed a pivotal part of the scheme. And then he says, a little further way down in that paragraph, sorry, I've lost my... Going on, he then sets out in rather greater detail the terms of the loan agreement, but your lordships will see that there was no exclusion of personal liability as such. And then he analysed the cases of Lumsden and Buchanan at paragraph 25 and Muir and Citibank at 26. And his conclusions to be found at paragraph 27 on 21467. sorry, my numbering seems to have gone wrong here. 21467, okay. Mr. Richardson argued that even if the loan agreement was to be construed so as to show that the defenders entered into it as trustees of the trust, that would not restrict their liability in the manner sought. So Mr. Richardson was Mr. Brown's. I do not think the position is as simple as that. Lord Blackburn and Muir said that it was not always enough of itself, that's to say it wasn't always enough of itself for a contract to say it was with a trustee, but it was an important element to be taken into account in construing the contract. The nature of the contract was important. Lord Cairns clearly thought it was a question to be determined having regard to all the circumstances, including the nature and subject matter of the contract. So too did Lord Wrenbury and Lord Cranworth in Lumsden and Buchanan. The contracts in those cases were contracts of co-partnership. In such contracts, there are obvious difficulties highlighted in the speech of Lord Wrenbury in one party seeking to limit his liability. So too, in many, possibly most everyday contracts. The circumstances of the present case are, however, very special. They point clearly to the defenders having contracted as trustees only. That was the nature of the scheme. The trust was making the loan available to the employee. Why would the defender advance the loan at all if he was not acting as trustee? On what basis could the defender on what basis could it be thought that the defender, though advancing the loan as trustee, was assuming personal liability for tax consequences of waiving repayment of that loan?
I mean, that's a bit odd, isn't it? I mean, just because the arrangement was structured as a trust, I haven't quite understood why. It was a trust which would make loans to the employees of the company for the purchase of shares.
Well, the way it worked was the company set up a scheme with under which the trustees either had shares in the company or had access to them. And it was part of the remuneration arrangements for the directors of the company.
But I mean, the company, I don't know whether it could have done it directly itself, the company, but it set up a trust. And the trust not only made the loans, but also it gave a very important promise to indemnify the pursuer against any tax liability arising therefrom. And the effect of this decision is that the promise was effectively watered down insofar as it was only enforceable so far as the assets of the trust allowed. Why should one could ask the opposite question to the one the learned judge asked, which is why should one assume that the unfortunate employee would regard the undertaking he received as qualified in that way?
Because it was a form of remuneration, and ordinarily, if you receive remuneration, you expect to have to pay.
Well, is he going to get an indemnity against anyone else for the trust tax liability?
First of all, there was nothing to stop him getting it from the trust assets, if there were trust assets.
Right, well, I mean, that's good.
But the point is, he was getting...
no right to get it from the company, which probably should have done this itself.
But anyway. he was in a position where he was getting a form of remuneration and was taxed on it. And in those circumstances, the proper inference was that there was no intention that the trustees' liability was intended to be a personal one as opposed to liability as trustee.
That's the wrong way around to ask the point, is it? Right. You're looking for an indication that the prima facie rule has been displaced.
Well, an equally possible inference is that if you're looking from the point of view of the employees, is that the trustees would make jolly sure that they had the money to meet the tax indemnities rather than simply paying everything they got from the employees back to the company.
Or they had a back-to-back cover from the company.
Yes, or an indemnity from the company, indeed. Yeah.
I mean, this is anyway.
I don't think there's any evidence of such a...
No, I mean, anyway, it's a first instance application of what were thought to be the principles.
But with respect, my Lord, it does indicate how by what we'd say an application of modern principles of construction, one can look at all the circumstances, and the phrase "as trustees" may or may not connote that the trustee is liable only in its representative capacity. It's not decisive.
But in the way the way he deals with Lord Blackburn is slightly misleading with respect, because you go back to the passage of Lord Blackburn, which is quoted on page 21466. Lord Blackburn was specifically dispelling the impression created by Gordon and Campbell that it was enough just to say, as trustee. And he says that that's an important factor to be taken into account, but it's certainly not by itself enough. So that the emphasis of Lord Blackburn isn't to sort of encourage you to think that merely because you're contracting as trustee, that's going to be good enough.
I would respectfully agree with you, my lord, but it's not a factor which one can simply ignore if there are other factors too which reinforce the impression that those words are capable of meaning. Those words are capable of meaning that the liability is intended to be limited and not to be personal. And so one has to look at a combination of both those words and the... Can I just wrap up? I think I'm actually still on time.
I think we should wrap up, more or less.
The only other authority I was going to take your lordships to was the authority of very recent authorities, Wood and Capital Services, which my Lord Hodge. But perhaps...
yes, I mean, I think we're pretty familiar with it and pretty unlikely to want to add or subtract.
I didn't imagine you would. But the important point made in our respectful submission in Wood, I won't take it because your lordship is thoroughly aware of it, but in the context of formal written contracts, obviously one looks very carefully at the words that the parties have used because they've been drawn up by lawyers, and lawyers can be expected to use language in the way that gives effect to one's intentions. By contrast, where one has very informal arrangements of this kind, then looking at the background and the wider context to find the objective meaning of the parties is much more important. And as was said there, the factual background known to the parties they did contract is relevant to this task of interpreting it. So, your lordships will be thoroughly familiar with that, but it's at paragraphs 10 and 13 of the judgment. So it's we do rely on that passage about the importance of the fact that this is such an informal course of dealing that was taking place.
Thank you. Very much. Yes. Great.
My lords, my friend suggested there was no presumption so far as this is concerned. I wonder if I could invite your lordships on the law to look at what the Trust Law Committee thought the law was in 1997. It's at tab 17 at 237. The bundle page is electronically is 26620. And this is the committee under Professor Hayton, which said at paragraph 2.33 on that page, there's a strong presumption that a trustee will be personally liable when contracting as trustee, so that a contract entered into by a trustee, quotes, as trustee, renders him personally liable. The onus is on the trustee to show that the parties intended the trustee not to be personally liable. If the trustee contracts as trustee but not otherwise, and not otherwise, then he'll be personally liable only to the extent he has a right of indemnity, etc., which I suggest was rather the position that your lordships were putting to Mr. Taub. There are many cases in which as trustee has been found to be insufficient. They're listed in footnote 1 of our submissions, on the record 14074. That's in Appendix Bundle 2 behind tab 29. I won't obviously go through them all, but there are many cases where, as trustee, has been held to be insufficient. The positions also, while we're in Bundle 17, at 222, summarised in Lewis, Lewin, beg your pardon, on trusts.
What's the MS number?
MS number is 26401. Which were at paragraph 21/011. The authors say this: a trustee who enters into a contract will generally be personally liable under the contract, like other contracting parties, subject to any contractual limitation on the trustee's liabilities. Personal liability to the other contracting parties will be unlimited. The cases in my submission demonstrate, I think, 4 propositions. The first proposition is that we call it the default position, is that a trustee who enters a contract with a third party will be personally liable under it, like any other contracting party would. I've just shown your lordships Lewin on that. It's also, if we could go briefly to the Lumsden case, which I know my Lord Mans has obviously looked at recently. That's in
the following paragraph of Lewin,
it touches on this
21012, is rather in line with Mr. Taub's submissions, isn't it?
There can be a question of construction in the circumstances.
Well, yes, but he says, even without the inclusion of words such as only or but not otherwise, the terms of a contract referring to a party's status as trustee, although not sufficient in all cases, may, having regard to circumstances pointing against an intention, for the trustee to assume unlimited personal liability and not rebutted by other circumstances, suffice to enable the court to construe it as limited. That essentially is the submission against you. Of course, that doesn't get one home if one isn't satisfied that the surrounding circumstances in question are actually do point that way. But the concept appears to be perfectly orthodox.
Well, I would suggest that the cases don't go so far as Lewin suggests there, and certainly if one is looking at all the circumstances of the case, that obviously has to be read in the light of the modern authorities.
Well, Brown and Rysaf and Investec Trust are given as the authorities of that proposition.
I think your Lordship has, yes. I'm afraid Rysaf...
Lord Penzance seems to be invoked.
Well, I'm just going to go to Lord Penzance. Rysaf is the outlier, is an outlier case. And in our submission, it was decided on very special facts. But in fact, Lord Glennie described the case before him as being very special. And it, in our submission, failed to apply the authorities. If I could take your Lordship to a couple of those authorities, perhaps I could go first to the Lumsden case at 1011. The electronic reference is 23596, Lord Cranworth.
Reference again, sorry,
23596.
596. Thank you.
This is a decision of the House of Lords in 1865, and one has, towards the foot of the page, at the picking the matter up 3/4 of the way down the page, there's a passage as follows. It may probably be from these circumstances that in England, when a trustee enters into a contract describing himself as a trustee or is contracting as a trustee, that has never been held to qualify or restrict the extent of his engagement. Such words may be useful as between the trustee and those who are beneficially interested, but as to third parties, they are inoperative. He's dealing with property over which he has complete dominion and is understood to be contracting as absolutely as if he were dealing on his own account. If he means to limit his liability by the amount of the trust funds, he must do this by making express provision for the purpose. Now, my lords, that's in our submission is a correct, remains a correct statement of the law. The
law of contracts since 1865 has progressively increased the emphasis on the surrounding circumstances as a guide to what language may be taken to mean.
My Lord, I accept that, although they still have to be admissible surrounding circumstances in accordance with the authorities. So that would exclude subjective intent and exclude negotiations.
They've got to be genuine matters of background, although when you're dealing with a contract made by a course of dealing,
well, I will come to the course of dealing point,
matters.
But one is involved in this rather particular exercise here, because there isn't even said to be an express contract to construe. The second proposition, my lords, was that is to accept that a trustee can limit its personal liability, and whether the trustee has done so under a particular contract will be a question of construing the contract. Now, it may be that I don't need to go to particular authority on that, because I think that may be common. That part of my submission may be common ground. But there's a gloss on that. There are two glosses on that. One is that the cases demonstrate that, which is my third point, that it will generally not be enough to limit personal liability for a contracting party to describe himself as acting as trustee. And in that regard, one has seen the Rawlinson case, that is expressly stated in the passage that I have just mentioned, never been held to qualify or restrict the extent of his engagement. Perhaps one could just look at what's said in Muir at 11.126, also a House of Lords decision. The electronic reference, 11 please. The electronic reference is 23997. 11 tab 126. And if one goes to what Lord Blackburn said about this at 388, just starting halfway down the page on the left-hand side, there was an opinion entertained by many Scotch lawyers, and to some extent countenanced by the decision in Gordon and Campbell, that by the law of Scotland, a mere statement on the face of the contract that the contractors were trustees and entered into the contract because they were trustees was as a matter of law enough to express that the engagement was of this kind. I do not, speaking for myself, doubt that it's an important element to be taken into consideration in construing the contract, but I think the decision in Lumsden determines that it is not by itself enough to give any contract this limited effect, and certainly that it's not enough to do so when the contract is a contract of co-partnership, the nature of which would make such a limited engagement, to say the least, very inconvenient. Saying effectively not enough, and the Gordon case, of course, as one sees from citations elsewhere, was a case where it was said only as trustee, effectively a use of the but not otherwise wording in that case. And in fact, in Lumsden, there's a comment by Lord Cranworth at page 95 where he says that would have been decided differently under the law of England. That's at 23596. My lords, the fourth point I was going to make on the cases is that the cases do indicate in my submission that to exclude personal liability as a trustee, you have to use clear language. For that, obviously, one can go back to Lumsden, volume 10 at tab 111, the electronic bundle, page 23596.
So does it follow that it's impossible in your submission, if you have a contract inferred, or largely inferred, from conduct, to exclude personal liability?
Well, my lord, it would be a departure and very unusual. Conceptually, I suppose one couldn't rule it out completely, that if circumstances were extremely strong. But it would be unusual. It's not something that has happened before. And in our submission, what the cases point to is that one really should be looking for clear language. If you can't even do it by unclear language, doing it by by conduct is going to be quite a tall order. And in Lumsden, what is in the passage I read to your lordships earlier in Lumsden at 23596, towards the foot of the page, we got an express statement by Lord excuse me, Lord Cranworth in that case, that you must do so, if you're going to exclude liability, you must do so, but he says, by making express stipulation. That's the end of the last full paragraph. And in your, where we were a moment ago, which is 11126, electronic, page 23997, Lord Blackburn says, if he uses the expression sufficient clearness. Perhaps I should just go there. It's in the report. It's at
23997.
23997, my lord. Yes. So at internal page 388, and he says in the middle of the page. In fact, perhaps I should read the passage. This is coming from Lord Blackburn in the middle of the page. I myself no doubt that if individuals enter into a contract because they are trustees for the benefit of the trust, it would be prudent in them to stipulate that they bind themselves to see that the trust funds are properly applied to fulfill the contract, their contract shall extend no further, and that they will not be personally liable to make good sufficiency, if any. If they express such a limitation with sufficient clearness, and the other contracting party, being sufficiently curious, accepts such a limited agreement, cannot call on the trustees to do more than fulfill that limited agreement. So if it is impossible to do it, but in my submission, you've got House of Lords saying in two cases, either express provision needed or sufficient clearness. And indeed, while we're on
These dicta, of course, are in the context of a written contract of co-partnery, which no doubt was a fairly sophisticated document.
They are indeed. We have an odd situation here, because effectively what the case now being put is a course of dealing case, that there was a contract by, that your lordships are not, unusually not being asked to construe a document that my friend puts forward as the written contract in this case. What your lordships are being asked to do is to infer that there was a contract by course of dealing, and that one of its terms was that there would be limited liability, which is an unusual situation indeed, an unprecedented situation, I think, as far as the cases are concerned. Lord Penzance in Muir at 23977, internal page 368, also had something to say on this point, which is that something more, something necessary, something is necessary beyond the fact you know the other party is dealing as a trustee. And one sees that in the last third of the page at 23977, where Lord Penzance says, but to exonerate a trustee, something more is necessary beyond the knowledge of those who deal with him, that he's acting in capacity. And it would not be sufficient in all cases to state that fact in the face of any contracts he may make. To exonerate him would be necessary to show that upon a proper interpretation of any contract he had made, viewed as a whole in its language, its incidents, and its subject matter, the intention of the parties to that contract was apparent that his personal liability should be excluded. That although he was a contracting party to the obligation, the creditors should look to the trust estate alone. Now,
well, that's considerably broader than an express statement.
Well, my lord, I don't exclude in principle the possibility that circumstances
But you
might
say you'd have to be exceptional.
They would have to be pretty exceptional, yes, given that you have these authorities saying you really need clear language and something obviously beyond just the knowledge that the other party is acting as a trustee. And it would also, perhaps I should say this, it would also be consistent, we've cited this in our written submissions, with the approach to exclusion clauses generally, which generally require clear language, as we know. And we would say that that policy was well justified in relation to trustees because, first of all, it's a radical departure from the default or general position of personal liability. And secondly, and importantly in our submission, you get difficult issues which arise as to the practical operation of a limitation clause as to what its scope and effect is. Because, and we've indicated some of these in our written submissions, you get a problem with certainty of operation. How is the clause supposed to work? Now, I make that point because as we have noted, the clause, the term put forward by the former trustees has changed, is now in its fourth iteration from the as originally put. In the pleadings, it appeared as simply not personally liable. In the trial skeleton, it said that the creditor should that it was limited by reference to the value of the trust assets. Then in oral closings, and one sees this from Lieutenant Bailiff Chadwick's ruling, the former trustees accepted a formulation that the trustee was not liable beyond the right of recourse to the trust assets. Now that, of course, is not the same as the value of the trust assets, because an indemnity right can be lost. The point is, we have another iteration again in the written case before your lordships, which is to say, looks rather like Article 32(1)(a), funnily enough, not personally liable, but only liable as trustees to the extent of the trust property, I think is the term.
Where is that?
That is in Appeal Documents 2, tab 24.
MS number?
And the electronic page 13897. This is page 12 of my friend's submissions on this, and one sees it at paragraph 33, sub 2. If Article 32 is not applicable, the former trustee's case is that under each contract of loan between them and Glenalla and Thorson, their liability is solely as trustees and limited to the extent of the trust property, either as a matter of the construction of the loan contract or under an implied term. So that's the case your lordships are being invited to address. Now, the first point on that is that the different formulations of this term can have different consequences. And if you have difficulty in formulating your term and you have to change the formulation, at a minimum that shows that it isn't something that goes without saying. And it also shows that important issues will arise on its operation as to who is entitled to judgment for what amount, what happens if you lose the right of indemnity, what if there's more than one creditor, if it's a question of being limited to the value of the trust assets, when do you value the trust assets, how do you value them? And it's not, in my submission, enough to say, well, now we've gone for the option of some kind of non-recourse agreement. That solves things because something else Lewin says in the passage I looked to a moment ago, he says at 221.015, he says that the effect of the term providing for payment out of the trust funds is not altogether clear. And then he postulates, well, is it dependent on the right of subrogation? Is an equitable charge created? What about priorities? And so on. So you get to a situation where the law may have to imply a whole framework of sub-terms in order to decide how to operate a term that purports to limit a trustee's liability. I take it, I accept fully that some of this is what the Jersey legislature has purported to do in Article 32(1)(a), but if there is a statute, you have no choice but to try and work out its consequences. But that's very different from the idea that the parties have voluntarily assumed this limitation, agreed this limitation, without actually having given any thought whatsoever to what the practical operation of the term might have been. And just on the point about the justification for needing clear words, because of course, if one were to impose limited liability in an unclear situation, there's a real danger for creditors, of course, because the creditors risk having a trust with depleted assets, because of course the assets are entirely under the control of the trustee, and of course the trustee could reduce the assets, even entirely legitimately, by distributions to beneficiaries and so on, which would put the creditor in an extremely vulnerable position, particularly if they didn't think or know or fully understand or expressly understand that they had agreed this limitation, and so on. And of course, there's also the danger that a breach of trust claim will interfere with the trustee's right of indemnity and leave the creditor very exposed indeed. Now, RISAF, I did mention a moment ago, it's in Bundle 4, tab 51. Lord Glennie in the Scottish Court of Session, at 21469, he refers to the fact, my friend did take you to this passage, beg pardon, 21467, paragraph 27, he does refer to the fact that the facts he regarded as very special. It says so in terms. In our submission, therefore, obviously, a first instance case that may well be distinguishable and is indeed in our submission distinguishable.
But were the facts very special?
Very special, about just above halfway down the page, where he says...
Well, I appreciate he says it, but were they?
Usually a phrase used by judges when they're not entirely sure and want to protect their decision.
Well, in my submission, there was no relevant distinction in this case, and the decision is wrong. In our submission...
Well, I thought it was.
Well, that is understandable, I think, because what's special is that it's a trust mechanism.
Well, this is not stated in the judgment, my lords, but an undercurrent in this case may have been that this appears to have been a tax avoidance scheme of some kind. And it may be that the learned judge was in some way affected by the fact that...
Why should the fact that it was a tax avoidance scheme...
Well, it shouldn't
leave the liability with the employee rather than the company or the trustee?
Well, quite, but it may have affected how he viewed the employee getting the benefit and so on, and not wanting the employee to get access to the trustee's personal assets.
Well, we can't really speculate about that.
One speculate.
He says it's special, that's all.
He says it's special. And we say didn't apply the authorities properly because as trustee isn't enough. And the fact that he failed to apply, in my submission, the authorities properly because as trustee isn't enough, shouldn't have been enough, clear language should have been needed. And to say the trustee only entered these contracts because he was a trustee would apply to almost every case. And knowing that the other party was contracting as trustee would apply to very many cases. So dealing with the facts, if I may, my lords, as I mentioned...
Very little to say on the facts, isn't there? I mean,
well,
they seem to be extraordinarily simple transactions insofar as they're recorded.
Yeah. Yes, there's no dispute in this case that these loans existed, and they existed before the novations in August of 2007. That's not in question. And my friend also accepts expressly there's no formal loan document. So he's not asking you to construe a formal loan agreement. In fact, the former trustees say correctly that the deeds of novation did not alter the loan terms and don't constitute the loan terms. So we are not dealing with an express contract that the court is being asked to construe, albeit the matter seems to have been put to the Court of Appeal and understood by them as a matter of construction. Now, what is put now before the board is a contract by a course of dealing, and Mrs. Bleasdale's conduct is referred to, and it said, well, there was this practice where there'd be an investment recommendation, payment instructions, resolutions on both sides, posting to the ledgers and so on. But of course, if you're going to prove a term by course of dealing, you're generally looking at, for example, instances where the term was tested, the party's understanding was tested as to whether this was personal liability or not. And in this case, there's not a single instance, a contemporaneous instance of the issue being tested. I suppose you could say it's getting its ultimate test now. But principles of construction apply to express language. And here, the former trustees are putting forward no language at all that the board is being asked to construe as an express contract. What we're engaged in, it would seem to us, is a separate exercise of saying, can you prove this term by a course of dealing? In our submission, that is a pretty difficult exercise, given that the default position is personal liability, and the authorities being in the terms that they are, saying you really ought to have this very clearly expressed. Nevertheless, the situation we have is that the former trustees have expressly disavowed a case that we are construing, for example, the deed of novation. And the deed of novation, which I should go to briefly, It's in core 1 at 469 for Thorson. Similar terms applying to both loans. And Mr. Taub took your lordships there briefly just to show you the first page.
So, sorry, could you give me the page again?
469, core 1, 469, my lord. And the Mr. Taub showed your lordships the first page in the reference to capacities trustees, but of course there is a little bit more to this document than that, and over the page at 470, this is when the loans are novated between the two trusts, and it says at 470, one finds in the recitals at A.
Sorry, what MS are we on?
MS 470.
Oh, 470, it is. Yeah.
It is 470, yes, my lord.
Yes.
One sees the recitals in the second half of the page. It says a loan facility is in place. So the contract pre-exists. This isn't the contract. It pre-exists between the company and the trustee, under which, and then there's a recital, and it ends with saying the loan facility is unsecured, interest-free, and repayable on demand, the terms. Then at recital C, it says the trustee wishes to be released and discharged. Company has agreed to release and discharge the trustee from the performance of the loan facility upon the terms that the transferee trustees shall jointly and severally undertake to perform the loan agreement and to be bound by the terms. And across the top of 471, clause 1, the transferee trustees jointly and severally undertake to perform all the obligations of the trustee under the loan facility and to be bound by the terms in every way. Now, that seems to us to be entirely inconsistent with the case that there was a course of dealing term restricted to personal liability, because, of course, one's usual understanding of joint and several liability would be that each of the trustees is liable for the performance of the whole. And that would be one's usual understanding of what joint and several liability is. So we would suggest that insofar as this is a surrounding circumstance, it's inconsistent with the limitation of liability. Capacity as trustee isn't enough on the authorities, and one can well see in my submission why the former trustees eschew reliance on this as evidencing the contract. But as to deal briefly, my lords, with the circumstances which are relied on, I think I can rattle through these, my lord. The circumstances relied on by the former trustees. First of all, there's the circumstances that the companies knew they were acting as trustees. Well, on the cases, that's correct, but on the authorities, that's insufficient. Then the internal arrangements point. This, in our submission, proceeds on the basis that the companies are not truly separate persons. The BVI companies are separate companies. They're not just trust bank accounts, and it's wrong in principle to treat them as such. Transactions between the trustee and company, one should not, for any purpose, and indeed for this purpose, conveniently ignore them. I mean,
I'm not sure how its full impact would be that these arrangements aren't intended to be legally binding at all. How you would stop at the halfway point and say, well, on that basis.
Your Lordship has the position, that has the point that the logic of that position is to say that they weren't genuine loans at all, and that they were not intended. And of course, that they can't. The reason they can't say that is because they took advantage of the arrangements having separate companies and loans for other purposes, like tax purposes and so forth. There is a passage from Lord Justice. Beg your pardon, Lieutenant Bailiff Chadwick. Perhaps I'll just show you that at Core 1 at 226. So it's electronic 226 in the Lieutenant Bailiff's judgment, where he describes these arrangements in the middle of 226 at sub 3, where he says the loans are internal arrangements between the former trustees acting as such in companies in which the TDT held shares, that is, companies in the trust structure. Their purpose was to move funds within the structure from those companies, particularly Thorson, which had funds available to them, to those companies which required them, and to do so in a manner that did not give rise to potentially adverse taxation consequences by generating income within the structure. Furthermore, the purpose of moving funds was to use the money for the benefit of the trust estate by permitting investments to be purchased or serviced or for the payment of necessary administrative expenses. So you have a situation where the trust is taking advantage, first of all, of separate corporate identity of the companies to limit their liability, and also at the same time is able to move funds around, avoiding potentially adverse tax consequences, because so these loans had to be genuine loans, otherwise you might get into dividends and gifts which might have had tax consequences, as the Lieutenant Bailiff found and was never...
Well, strictly that's a summary of the former trustee's submission rather than a finding, but you say it comes from the mouths of those who are arguing otherwise.
Indeed, and what it comes down to in our submission is you can't take the benefit and burden go together. If you're going to use separate corporations, you use them, the loans are genuine, you must treat them as genuine loans, and you can't pick and choose when it doesn't suit you when it comes to personal liability. I should perhaps just add as a footnote to that, I would suggest that the Court of Appeal's comments about this were particularly inappropriate, because they effectively said, as the basis for them finding a limitation of liability, they said, well, neither the trustees nor the companies had any real say in this because it was all directed from R20 and from above, I think was the expression used. Now, obviously one is aware of the press coverage of the Paradise Papers and so forth, and it's not, I would suggest, helpful for the Guernsey court to be encouraging a view held by some of the general public that trustees in offshore trusts don't make independent decisions, or that directors of companies in offshore trusts don't make independent decisions, because the logic of that position might be that there's not actually a proper trust at all. Yeah. And that could itself have tax consequences. So just rattling on through my friend's points, there was, he said it was inherently improbable. The term would have been agreed. Well, it's difficult for us to see how it's inherently improbable if it's actually the default position that applies in most cases. He relies in his written submissions on the fact the trust was administered in Guernsey, which has section 42 as being a relevant circumstance. Well, in our submission, insofar as that's relied on as an objective circumstance, it's irrelevant, because the TFT which entered these loans was a BVI trust, and the creditors are BVI creditors. Section 42 only applies to Guernsey trusts, as we saw. And even when it became the TDT, it was a Jersey trust, not a Guernsey trust. And insofar as it's relied on as a subjective matter, which may be inadmissible anyway, the Lieutenant Bailiff expressly found at paragraph 196 that the individuals concerned did not appreciate that the trustee's liability might be limited by legislation. And that factual finding has never been challenged. So they just did not appreciate the effect of the legislation, the individuals dealing with this matter, according to the Lieutenant Bailiff. The final matter relied on, I think, was the books and records of the trust. And in our submission, as has been pointed out, it's pretty hard to see how the trustees could have kept proper books of account without recording these as trust transactions. And in the end, describing the trustees as a shareholder or a loan to the trust in the resolutions really takes the matter no further. My Lords, unless I can assist you further, those are my submissions.
I think I'm right in saying that you've
We're up to date.
caught up
I think we have.
deal of time.
I think we have, my Lord.
Congratulations can be transferred.
Yes, I will now.
We now go.
Assume Lord Goldsmith congratulations.
I'll
put that on my website.
by
CV, I think.
novation, possibly, but certainly by assignment from here. Yes, thank you.
It's a contractual matter.
Right. I think it's Mr. Cater again. Is it? No, Mr. Taub, sorry, Mr. Taub.
My Lords, can I respond to a number of points Mr. McQuater has made? First of all, he addressed your Lordships on the footing that the relevant law governing these transactions was the law of England, and he cited authorities from particular which stated, for example, by Lord Cranworth in Lumsden and Buchanan, what the law in England was in 1865. And I'd make 2 points about that. First of all, obviously his remarks are obiter, but secondly, and more importantly, that was a time, 1865, before the fusion of law and equity. And the common law problems which I identified yesterday as existing where trustees contracted were plainly in existence at that time. The point is that in a common law court, if you sued on a debt, the trustee separate capacity wasn't recognised. He was simply sued as a person, as an individual. And the judgment that was obtained against him was against him personally, whether he was a trustee or not. So one has to bear in mind that those remarks in Lumsden and Buchanan are given in that context.
But that's a submission we haven't heard before, I think, orally. It would involve that subsequent authority, and particularly textbook writing we've seen, has completely failed to take it on board. Namely.
I think the position, just stepping back and trying to understand what textbook writers have thought, is that there are dicta in these 1865 and 1879 case, and they're dicta, I stress, which certainly give the impression that one has to have an express stipulation to exclude personal liability. But if one thinks about how modern courts approach questions of construction,
yes, well,
it is possible for terms to be
emerge out of the ether. Yeah.
Yes, but the comment may be an obiter dictum, but I mean, Lumsden was a Scottish case where equity and common law were not separated.
My lord, I entirely accept that. There was a quotation
that particular
from
quotation
about what the law of England was.
I see.
And that's why I was referring to it, my lord.
Yes. But it was suggesting that there wasn't much difference between the law of England and the law of Scotland on this matter.
It was the passage, I think, at 95 internally, or 23596 in Lumsden.
Yes.
About what Lord Cranmer said the state of English law was at the time, and the point I'm making.
I mean, I imagine the fact that they couldn't apply equity law didn't mean in 1865, I imagine, that they couldn't recognise it as existing, and indeed they refer to trustees quite happily and so on in Lumsden. So how far does your submission go?
Well,
Not very. I mean, the Trust Law Committee, very distinguished in 1997, clearly thought that was the position.
well, if you look at the
They got it all wrong.
authorities, the two authorities that they gave were Muir
Yes.
and Glasgow Bank, which, as I respectfully suggest, is more nuanced,
And
certainly.
Robinson settlement.
And Robinson is a case where, it isn't, I think, in the bundle, but Lord Justice Buckley, at page 728, 729, concluded that the reference to trustees, contracting as trustees only in that case, was sufficient to exclude personal liability. It was the case was decided on two bases.
Yeah. No, the Trust Law Committee, I think you're a member of it.
I was on the working party, my lord, yes. I can't claim authorship of the entirety of it.
A very distinguished committee. Clearly thought this was the law, and you're now putting forward for the first time a proposition which seems to be turning the whole thing on its head.
Well, one has to look at the two authorities cited there, and do they go as far? Very distinguished the members were. One has to look at Muir, and one has to look at Robinson. And Robinson, having now looked at it, does not go nearly as far as is suggested there. Robinson, as I say, at page 728, 729,
Have an electronic.
it's 1912. I've got some soft hard copies. My juniors seem to have got.
Is it not in the electronic?
No, it isn't, which is the reason. I mean, it was. it was when my learned friend cited that passage from the Trust Law Committee that
Yes.
I realised that there was liable to be confusion.
Where is it cited in the Trust Law Committee? It must be in the footnote.
It was the passage, my learned friend cited a passage from the Trust Law Committee.
2.33, yes.
Yeah.
And then you see the footnote in support.
Oh, it's Robinson settlement. Yes, I'm with you. Yeah.
Thank you.
1912.
Yeah.
I think we'd better look at the facts, partly to remind myself. But this was a marriage settlement case. Our assigned funds trustees, under which he took a protected life interest, and the trustees were empowered to pay his debts, and for that purpose to raise money upon his request in writing. He committed an act of bankruptcy on which he was adjudicated a bankrupt. He signed a request to the trustees to raise £800 for the payment of his debts. They borrowed the money from G and executed a mortgage in which they covenanted as such trustees, but not otherwise, to repay the money with interest at 6%. G brought this action to enforce his security. Mr. Justice Warrington held that G was an unregistered money lender, but the mortgage was valid because it was not taken in the course of his money as a business as money lender, but as a private investment. R's consent was a protected transaction within Section 49 of the Bankruptcy Act, and the trustees, one of whom had not pleaded the Money Lenders Act, were personally liable on the covenant. So the decision was a decision on the Money Lenders Act, but in case the matter went further, Lord Justice Buckley considered the question of personal liability or not at page 728, 729. And one finds that halfway down, page 728. I want to say a word on another point which has been argued by Mr. Terrell, because Mr. Cave has indicated this case may go further, and if it does, I think the House of Lords are entitled to know our view. The covenant in question is a covenant by Stevens and Hobbs as such trustees, but not otherwise. The language is, in pursuance of the agreement, and then he describes the terms, consideration, being paid to R, testified by his being a party, the trustees as such trustees, but not otherwise, covenant with the mortgagee to pay him £800 with interest from the date of these presents. On the decision of the House of Lords in Gordon and Campbell, and the decision in Muir and City of Glasgow Bank, particularly the language of Lord Cairns, and that was the passage 355, which I've already cited to your lordships. So that referred to the, if you recall, the construction, circumstances surrounding the contract, and subject matter, particularly the language of Lord Cairns at 355. This covenant as trustees was, I think, not a covenant which bound Stevens personally. It was a covenant which bound only the two trustees in respect to the trust funds in their hands at the date of the issue of the writ. In 1907, when the writ was issued, there were no funds in their hands. Gordon and Campbell, and then he describes the effect of Gordon and Campbell, which your lordships have already seen. The House held there was no personal liability in Gordon and Campbell, and then he describes the effect of Muir. He says, in Muir, a case in which the trustees were held liable for reasons which were clearly stated by the House, Lord Cairns put this example. If, for example, A, B, the executor of X, contracted to make a payment as executor of X, as executor only to C, it would be difficult to suppose that any obligation, except an obligation to pay out of the assets, was intended. In my opinion, Gordon and Campbell and the language of Lord Cairns and Muir are applicable, and this covenant as trustees is not a covenant that binds Stevens personally. Now, I accept that the words "and not otherwise" are there, and that is, as a narrow point of distinction, a distinction between the two cases. But, my lords, when one looks at the context of what occurred here and the language was used, I respectfully submit that this is a case where saying ITGL was contracting as trustee ought to be given the same meaning and effect as in the case of Rawlinson, Lord Justice Buckley thought was the position. Now, there is the further point, as I mentioned a little earlier. Your Lordships were addressed on the footing that the law that governed this informal contract was the law of England. There is no finding to that effect. There is nothing to suggest that the relevant people at ITGL contemplated they were contracting under under English law contract principles.
I mean, the fact that someone was on the same side, on both sides in some transactions and was sitting in Guernsey might point towards Guernsey.
My Lord,
Might it?
subjective intention maybe is rejected as an approach, but if one asks what is the context in which these documents were being executed, it was in Guernsey. All the employees were there, and that is not a jurisdiction where the default rule is that trustees are liable personally on their contracts. The default rule is that they're not liable. So absent a finding, and there is no finding that English law governed these.
Well, that depends on the correctness of your submissions, and we are at the moment assuming that your submissions about Article 32 are wrong, aren't we?
My Lord, yes. Yeah.
So on that footing, it's not the default position.
No, with respect, my Lord, Article 32 is Jersey law.
No, it was the other parallel Guernsey article that's been put. You say Guernsey common law, trustees are not...
Well, as a matter of Guernsey law, it's not common law, it's just a matter of Guernsey law where you have a Guernsey trust. I think this is my Lord Sumption's point, which is fundamentally, if I might say, absolutely right. We're not dealing with the Guernsey Trust.
Yes.
I accept that.
But I mean, if you're wrong about Article 32, you must also be wrong about the first subclause of the equivalent provision in Guernsey, because it says the same.
Well, my Lord, it couldn't possibly apply to this trust because it wasn't a Guernsey trust, okay. and I accept that. But what I would say is that the background, part of the matrix, is that was a jurisdiction, at least where there are Guernsey trusts, where trustees are not liable ordinarily in a personal capacity as opposed to a representative capacity. The next point was made that was, my learned friend, was that there was uncertainty about the operation of the implied term we were contending for. Well, your Lordships have seen from our case that the term that we're contending for, the term that we're contending for is in the same terms as both in the Guernsey statute and in the Jersey statute. So we don't see how it can be too uncertain to operate. If it can operate in either of those contexts, why can't it operate in this context, in a contract? And my learned friend then said that Rysaf was wrong, and in any event, it was distinguishable. My Lords, there is one important feature of this case which is different from Rysaf and many others, and that is that in Rysaf there were genuinely opposing parties, so to speak. There was Mr. Brown, who had his own personal interest, and on the other hand, the Rysaf Trust Company. So if one asks, as a matter of inference, from their conduct, what each of them might be thinking, they might well have different views about the matter. But here, I accept that the companies are different legal persons. Glenalla and Thorson are different legal persons from the trustee company. But the reality is that it was the same people on both sides of the transaction who were giving effect to the instructions for payment. And what my submission the court's being asked to do is, in circumstances where the parties were silent about the question of express term excluding liability or express term imposing personal liability, completely silent on the subject, one should infer in these really remarkably unusual circumstances that by making these entries in the books and by having these share resolutions, each side shared the intention, objectively evaluated, that ITGL should be personally liable. It's in our respectful submission, a curious inference to make in a non-English context where everything is taking place in Guernsey.
Yes,
My Lord, sorry.
So the submission, I think, before the Lieutenant Bailiff, on behalf of the former trustees, was that the proper law of the loan was Guernsey law, but the Lieutenant Bailiff didn't find it necessary to decide the point.
My Lord,
he
yes.
proceeded on the assumption that it was. I think that was where it was left.
I think he said, I don't need to make a final decision, save that it was not Jersey, which was the governing
that's
law.
right.
And then it could be Guernsey. Yeah. I'm prepared to assume that might have been England. But
yes, that's para 181 of his judgment.
Yes, that's absolutely right.
Against your proposition that all this was going on in Guernsey, one does have to set, doesn't one, the undoubted fact that all the participants, both the trust and the companies who were on your analysis on opposite sides of this loan, were foreign. Neither of them were Guernsey entities, or none of them were Guernsey entities. So that although they were sitting in Guernsey doing this business, they were transacting it between entirely, from a Guernsey perspective, foreign entities.
It's ITGL is a Guernsey resident company. It's Guernsey Incorporated. The TFT...
But it's actually, that's why I said, if you treat, as you do on your submission,
I
side as
see.
being
I
trust.
follow your Lordship's point. No, your Lordship is absolutely right that the TFT, it was governed by a different system of law, not Guernsey.
And the companies are BVI companies.
They are BVI companies, but their employees, as I'm saying, were all in, and the personal directors were all in.
I think the TFT was governed by BVI law as well, is it?
The TFT was governed by the law of the BVI, my Lord.
Yeah.
How are you doing, Mr. Taub? I think you've exhausted
I think
allocated time.
I think I hope I haven't indulged in what the late Mr. Leon Price used to describe as the most effective weapon of the advocate, repetition. But I have nothing further to say, unless your Lordships want to put a question to me.
Thank you very much. We'll look forward to moving to restitution at 2 o'clock.